That was the ladder. Pursuant to this ladder, the employees, the
read sir, total read, you read sir.
yes, align the IP pillar. Next ladder. Appealing government has formulated a scheme wherever all the eligible temporary class 4 employees, as also the open market candidates who have taken the established for recruitment as class 4 year 96. The respondents in these cases have the terms and conditions of the scheme are enumerated in the certificate and follow. One side those temporary workers who are working in the LIC for more than 5 years and retired all possessed no eligible participate in the area described at the relevant time of the entry to the site of the of this purpose, the LIC will hold a exam. The tickets first will be announced in advance. Successful classification candidates are part for the both persons who are appointed. Both the employees to the amount of the not substitution please. That way that both those who are recruited from the government by the regarding the past standard. So far as the open market candidate who had appeared in the relevant time and of course successfully saved the call for inclusion along with the conservation. In any case, not yet. Order. Pursuant to this, several candidates who are working in Hyderabad zone also applied that this they are seeking letter. These petitions have been petitions will not have been marked. Critics are at page number 4. So then that's proceeding the second.
You made a representation before the authorities.
Given representation, fight the director, the next like among the zone of consider they may consider there are several batches of they are also given that result not to be placed the other city with the right. Either dashboard and like they have been working with it. Actually, they have been working here even before the period which I have mentioned, but they didn't have documents because they are temporary employees. But I only filed some documents so that they are working. So that I have filed the vouchers, they have the vouchers of salary created in the account and paying 16, 17, 20, 21 years. These are the vouchers to show that they have been, they got the wages and the proof of receipt of wages as on the date of filing, I have filed. They are temporary employees, they don't have the appointment orders. The daily workers, no appointment order was given. They have been working in the airline. So, you have direct the allies, they come and get a loan of acceleration as per the Supreme Court. And the Honorable Supreme Court also recently in 2004 22 also, Lord, Ranveer Singh was the Sensera except India, Lord. Supreme Court has directed Lord that those who are working from 1985 to 91, they will be considered for regulation. Their cases can be referred to committee. So, I almost submit this that Lord, you'll ask me directly dispose of the restriction. Lord, if they direction that if they come under the zone of consideration as per the judgment of the Honorable Supreme Court, they will be considered. So, to that extent, Lord, I am seeking.
Yes, what is that?
May I please, the petition is filed, Madam, taking an declaration of the petition asking persons to the Honorable Supreme Court order. The last time is not under the Supreme Court order, very is a one-time measure. Those who are working as 5 years, as on 2011, there was persons which are being filed with the petitioner related to the later years. The last one, I see form done, Madam. Page number. Yes, I did two paragraph of the Para 9, Madam. It is further submitted that the petitioner did not work in the government for 5 years. Does not be produced by the document. Proof as stipulated in the notification data session. Consequently, the candidate for the petitioner who applied in the response to notification data is not all the eligible candidates among those who are applied in the response to are filed to given appointment and legal rights. It is further submitted to the petition and able to discuss on the ground of delay and after the time of the process was completed well back in 2012 and eligible and selected candidates were given appointment. Honorable Supreme Court has given a judgment is only one-time measure which has to be conducted in the year 2000 and in the same measure. Such of those temporary employees who do not apply or are not successful are to be in the employment, which is to be clarified. So, we have clearly stated in the counter, those who are not employed are liable to be terminated because only by virtue of the interim orders, not to replace them with similarly other papers, they will be continuing.
Is the matter is there in this matter?
In this case, there is no interest. In this case,
Because they are not liable for any declaration, in other words.
But then you are not properly assessed, not for item 6, other 4 cases for that. Immediately after this honorable court, then itself, before the exam is scheduled, as per the judgment of the bill. The condition stipulated therein was that the candidate must put in 5 years of service or in the cutoff date. They are also allowed to apply for the examination. That was almost Supreme Court just comment was right. Then the particular branch managers have not done it properly. Despite we have a vouchers, salary vouchers, then we offer this honorable court. Paid our vouchers also. Elaborated particular branch managers are not issued for various reasons. Then Justice Ellen that you have then, as far as specific direction, you continue them. My cases are pertains to 2011. From 2011 to till date, they are working on the same aspect. So now, until unless they have to be regulated in one aspect, by formulating under scheme.
Your case also is there in the list today.
Today, one case is there. My friend says is not continuing. But other 4 cases also there. Mine, they are continuing. Even latest course 2023 court slip. I mean, such receipt also I enclosed. Because what's my club all together. My friend knows all the cases about.
Supreme Court order. Now they may be continuing as of from 2011 to 2023. First, we may pass on the honorable division by judgment of this court. Any judgment passed against the order, sitting over the judgment of the Supreme Court, you have to approach the Supreme Court.
No.
The last may the order of the division bench.
What's my club all together will assist you. What's my pass and take any complaint.
Supreme Court has categorically stated that those who are not being recruited and the are not successful, they have to be terminated. They are judicial in the
How many matters is there, sir?
I have other cases.
Post all the matters after 2 weeks.
Take a comprehensive review. Because they are working for the more than nearly 20 years. In my case, they are bunch of retirement also. Some of them 50 cross, 45 cross. Now, at this stage, what they can do? What they are paying will not hardly for 100, 200 rupees per day. They not go for any other employment.
We have never stated the employer to continue in this matter. They are devoted to.
Even I.
Continue the LSA and join anywhere, madam. We never force them to continue the LSA.
You are disturbing the.
No, they cannot say they are giving us salary across the day.
Give it all the number.
So they are continuing that.
I produced the pay slips also January 2023
Yes,
also.
sir. Yes, sir. We are not, because they have been continuing by virtue of the Indian order. Not legal.
Item 6 also.
But the Honorable Supreme Court order.
Item 6 also after 2 weeks.
Yes.
2 weeks, period, I'll give some more deputation members. Yes.
Item 4, CH Ganesh.
It's Ganesh.
Item 4.
The matter of
challenging the termination order, handicapping the file.
post office 2 weeks. This is the council option.
Item 5,
Especially identified mass things, not support. They are going to take time, post, matters usual question, the best. No caption of special entry. Postman.
Item 5, TSHC number, people revenue.
Before the state, they are appointed in the year 2014.
Who's the other side?
On this point,
Actually, my own point is time whether the petition is based for considered promotion. But according to him, it was considered in 2018. He's seeking from 2017. Now in 2017, we have given the promotion, but to the seniority list which is prepared in 2010. They were appointed in 2014. The question of considering them in 2017 is not raised.
that back with the text.
But if that is the case, my last question, if that is the case, he has to challenge the promotion order, which he has given in 2019.
And the ST candidates, petitioners from the ST candidates, their rosters are 25 and 33. That they are appointed in the year 2014 as VROs. That their services were regularized in the year 2016. That they responded one effective promotion to the kindly peruse, phase 31, dated 24/8/2017.
Page
Phase 31. That's what.
counter later. Counter is not there, sir.
In a file now.
The count.
In fact, Ballard, not to think the wishes time are
Understood.
first time not. I'll say one thing, Ballard. 2019 promotion is staring at him, Ballard. He has to challenge that, Ballard. He has grievance regarding that. Having accepted 2019 promotion, he continued till now. In that promotion, now
He accepted one's promotion.
yes, he accepted 2019 promotion.
Application of happened by friendly last time for petition.
You file counter post after 2 weeks. Counter is not there, sir. You file your counter post after 2 weeks. It is not there in the bundle.
8/6/2018.
Post after 2 weeks. Sir, once you accepted the promotion, continuing till today, they are questioning the same. What is this?
After filing of the petition, they considered the promotion there 2019.
Okay, post after 2 weeks, we'll see.
Give the date.
Item 6, Sergeant Miller. Item 7, Penrice and Parent. Development and enforcement.
If you want. Post after 2 weeks.
Item 8, Prince Greenwood Baba. Thank you for honesty. Greenwood Baba.
The other side, forest, speaking for forest. This is one is there. The water is there. We will see post after 2 weeks. Nuclear post. Item 9, M. Salini. Vijay Kumar Gaur.
Detailed count is 5 just I have seen it now. Basic fact is by virtue of this one force direction, the response had to conduct detailed inquiry, Again, the inquiry is not properly conducted, it is very stiff punishment is inflicted. In fact, there was from the beginning, no inquiry was conducted, and charges were not proved. Therefore, I need to find that
The post after 2 weeks usual post. Item 10, S. Surendra Reddy, keeper for home. S. Surendra Reddy, DP for home. What is that? Little bit speak loudly, sir. Why they are not considering? Counter is filed, huh? Not filed. Contempt is also is there.
CC 1488 of 19.
Okay, listed so and so is the number last one. What are the post after 2 weeks?
148 up to 2019.
499.
148 up to 2019.
1488 of
2019.
98. Contempt.
You do also single.
52, sir.
You also same issue.
Nothing.
Okay, post after 2 weeks, 52 also.
First around.
Okay, post along with the same. Hey Ravi Mohan, hey Ravi Babu.
This item is not there. Subsequently, we have conducted an inquiry, imposed punishment. That is the punishment of this apparent punishment of
Okay, yes.
You have to be waiting in the granted department.
It's filing of manuals. The action second. Charge sheet. Number 01, obviously. 8, obviously, AR. Attached to dated.
I come forward. Kandaraju Rajshekar Rao, DP for services.
Kind out tomorrow, minutes. Instant next minute. Kind out tomorrow, minute.
Post after, day after tomorrow.
Item 13, MR Tigers, DP for services to.
Not pass out, day after tomorrow.
The Friday on the last 2 months, you can have to visit it, but then this cover or not.
Yes.
But you'll have them. It's fine.
Okay, day after tomorrow.
Suspicion.
Day after tomorrow.
Yes.
Yes.
Item 14, Kautal Kumar, DP for education. Services.
Implementation of the order of APA has already been advocated by the honorable APA. Page 23, the order passed. In implementation of the same.
Who is appearing other side? What is that you are not going to implement the order of the APAP?
But the counter will apply. The second proceeding we have issues to him that are feasible to consider. That proceeding is not immediate. I will just miss you. Okay.
Post after only.
Item 15, Arun Kumar, such a question.
Yes. The services of the second respondent, again 1987, still work. So when there was a discrepancy in the data, in the PF report, concerned PF report, he made a representation to the second respondent on 6/5/2015.
Yes, sir. Tell me the facts.
He was joining services, joining services on the second respondent, skilled worker, like in 1987. So
Skilled worker.
Unskilled worker in the 1987. But when there was a discrepancy in the paperwork of the petitioner, in the PF report, he made a representation to the second respondent on 6/5/2015, stating that the PF report, it has been wrongly mentioned as 16/1/1961 instead of 22/5/1963. So on verification of the records by the second respondent, on being satisfied, they asked the second respondent has asked the first respondent to correct the concerned records and do the corrections in the records of the corporation and also the concerned PF records. The letter, which is at page 14, is issued by the second respondent to the first respondent corporation managing director. So asking them to the correct of the correction. In the middle paragraph, it is also verified in this certificate issued by the England Local School Society, Hyderabad. Other copy which is also recorded 22/5/1963. Hence, I request the managing director to direct the concern to modify the date of birth as 22/5/1963 in the concerned register of the corporation and in the PF. But this was issued on 21/8/2015. When there was no correction with the second respondent act in the year 2017, which is the page 15. On 1st August 2017, and again another letter has been issued by the second respondent to the first respondent with the same request. May read the paragraph. Kind attention of the managing director is invited to subject the section cited and submit the B. Unskilled worker of identity submitted an submit request to the employer to make corrections in date of birth in TF reports and office reports as per this open school certificate. As it was wrongly recorded as 16/1/1961 instead of 22/5/1963. Thereafter, and again, another reminder was issued by the second respondent, which is at page 16, dated 8th March 2018, dated the same request, which is made in the earlier letters. But thereafter, the issue letter has been issued by the corporation. This is at page 11. Yes, this is the including the 17/12/2018.
There it persons of the instructions issued in reference cited, T.B. Viraya, unskilled worker working in IML depot. Adilabad district is informed that your date of birth recorded in the corporation is 16/1/1961. And then you are informed that from 16/1/2019, you will be attaining the age of superannuation of 58 years and will retire from the service of the corporation.
Get some service now.
Yes.
The account is also settled.
The what else?
The protest we have said, yes, informed me that he has taken the passion and the protest. You can see their own reports, which is at page 17. 17 is the report. It shows that the petitioner was working as the skilled worker and appointed on 19/3/1987 at serial number 18. Thereafter, page 19. This is the record prepared by the corporation. Top second line, 25/11/1993.
11/19.
1993. And in the next page, at page 20, serial number 22. D. Viraya. Date of birth is shown as 22/1963. And the date of joining is 19/3/1987. And at the last column 10, 7 pass certificate was submitted at the time of joining of the corporation. Which is the
There are several judgments are there, sir. Government of the years.
it's not connected.
When you join the service,
87.
87.
When you report
this mistake,
their own record, they have corrected numbers. Their own record shows that 1963 by date of birth. These are all their own records. And the ID card, which is issued by the corporation, is at page 29.
29. ID card.
ID card issued by the corporation itself. Date of birth is shown as 22/1963. The right side follows.
What sir? What is this? Gimmick. Your ID card showing is 1963.
It is issued by the manager without looking at the date of birth and all this. Whatever they did, they will sign it
While once you are retiring and service, what you will see?
and taking advantage of it.
No, not this one. And another also is there, same 1963.
That is only a
Which is also showing page number, item number.
statement of seniority. It should be the head office. That was sent by the bank manager. Basing on his representation.
When he was retired,
Prepared in the year 2018 itself.
all accounts settled.
Account settled numbers on the protest.
Under protest,
Nothing less.
Letter is issued. I clarify that letter also.
This is the. And this PF statement is given in every year. This person has joined in the year.
No protest, sir. Please, signature is there.
But a letter has been issued. I get that letter.
The post after 2 weeks.
Yes, issued a letter to the corporation first saying that he is receiving the amount.
Okay. Who is that letter will see?
Become 6 days. Very Praveen Kumar. Thank you for about
The same.
Not same person, usual person.
Person. See, the retired person, senior citizen members.
No, you have only very least chances. Major issue is over already. We'll see whether the protest letter is there, generally is there, then they will respond to that extent. Yes, Gadi Praveen Kumar. The post after 2 weeks. Admit would have okay, admit post after 4 weeks, soon you see. Let's still okay, don't say.
Last occasion,
We are not there.
the government asked you that.
pharmacy.
That's the national skill development.
You are there, sir.
Is challenging our confederation and the recruitment process. Says that he studied ITA. He says that he is different recruitment. He said that there is no instructions or proceedings by the government, state government, scientists is different in this.
Yes, therefore only the board.
Central government has no say in this matter. It is incompetent.
How is the central government responsible?
Notice that the board is committed to this one because the central government has to mention that because no,
No, central government has nothing.
10th class plus ITA equivalent to the 8th class plus 8 ITA is equivalent to 8th class.
No, my friends,
That is the memorandum of understanding with the national skill development. With the vocational course, like I
you know, should be taken in this memorandum of understanding invited page. 19.
It says to argue.
That's what I'm saying. Board is, no, what I'm saying is, I'm not saying board is not concerned. Central government has nothing to do with in this case.
That's what
equal.
I mentioned.
Central government is nothing.
All open schooling are.
Yes, sir. But open schooling, the millet may take your lordship to this.
Memorandum of understanding is for candidates who already
Already said, sir, it's ITA plus.
ITA is whoever completes 10th class and the 2 years of ITA equivalent to economic.
already produced that certificate.
No, that is the central government skill level, the skill director of the respondent number 3. That's the Ministry of Skill Development and Enterprise. That is the memorandum of understanding signed by these respondents. So therefore, my concern is I have just completed my ITA after my 10th class. Therefore, I must be treated as the equivalent to economic.
Show me that here, where is that?
That's the MOU, that's the page number 19, starts from 19.
Memorandum of Understanding, National Institute of Open Schooling, NIOS, and Directorate General Training. How
Yes.
far it is applicable to every course, every area, every zone?
Yes, but the IT, the 21 page,
There is
the IT,
understanding in between the National Institute of Open School and the Director General.
yes, but the director,
It is understanding of Union of India, the understanding of the state government.
but the understanding of the state government organizations, but it is again impacting the candidate, the candidate with the qualifications. Plus the ITA criteria, the page number 21. Plus the page number 20, there is 1.4. The aims and objectives of this committee. Page number 20.
Question is page 20.
One second, Ramaro.
Enable-
Where is your rejection order? Rejection order, they are not.
Pardon?
What is the case basically?
Basically, I have selected, provisionally selected.
For what post? Which post?
For the police recruitment, the ACTPC, plus the AR. That's
Where is the recruitment notification?
plus. My selection is below from
Show me the notification.
notification is page number 30.
30,
30 starts from 30.
36.
Page number 17, your last proceed. That's the minimum qualification. 1 second.
Page number 17.
Yes. Candidate must hold as an first of
There is a minimum education comprehensive candidates.
Yes.
Read it, this one once.
A pass certificate in intermediate or its equivalent examination recognized by the state government. In this case, the candidate belongs to scheduled caste and scheduled caste. Intermediate other. In case of the candidate belongs to SPST, yeah, 1st of July 2000, we must have passed the SST or equivalent examination recognized by the government. So here, my petitioner got selected.
How will it say, sir? Whatever you want to say. What is this?
Let's switch.
What is the qualification?
Qualification.
Intermediate or its equivalent examiner recognized by the state government.
Yes,
Where is the state government recognized for your ITA plus 10th class?
that's where the central government has come into picture.
That's my kind of.
Don't waste your energy, sir.
No,
Mark your point.
yes, ma'am, that's my
Your energy is required for this nation.
point. Is, my petitioner completed ITI after his tenth.
Correct, but the minimum qualification as per the notification is that intermediate equivalent to equivalent examination which is recognized by the state government.
Yes, ma'am.
Your intermediate or 10th to ITI is recognized by state government.
That has to come from the state central government. That because we
It is a question of send out. They themselves they acted said that recognized by state government. If it is your course is recognized by state government, or you are going to issue any certificate recognized by the state government saying that 10th class with ITI is equivalent to intermediate, will recognize.
that's the recognized.
No, sir.
Kindly come to the counter filed by the skill development. This is by 5 otherwise we lost the counter filed by both third and fourth respondent.
This is admitted or not? That you are admitted this one.
That's the usual procedure plus still in admissions.
Okay, rule is post after 4 weeks.
That's clean. Only 1 year is not the improvement is in progress. After 4 weeks again it becomes wrong.
And this is the case now itself. If it is so.
Yes, the kindly consultation.
Nothing is there. You show me register recognition from the state government.
So that's the where that lacking is. That is where I think the intelligence of this court. Therefore, only I made the parties of the central
When
government
the court to intelligence is required,
because I completed my NGA
if it information is right, there is a misunderstanding, then court can interfere.
Yes, sir.
State action is there, your must and should it is recognized by state government. Your ITI and 10th class is not recognized by state government. Show me one.
State government will not be aware of that one. Therefore, only I produce the memorandum of understanding between the two armies.
Memorandum of understanding between whom? State government and the so and so.
No, that's
Then-
not the central government.
Then
That is true.
central government, what is the central government?
That is to accord the permission for the
You
candidate.
don't only see post after 4 weeks.
No, can you see? You can pass any other class. But come to page number 3.
Yeah,
Sir,
4 weeks, sir.
they find
First of all, procedural aspect has to complete.
central government filed. Central government filed that one. Their
Government
concern.
counter knowledge.
Yes, sir. Counter filed by 4th, 3rd, 4th, 5th respondents. Therefore, my friend was this. They filed this one. And their
There is no
reference.
direction as to how they will file.
Office order.
There is no direction how they file.
Page number 3 minutes. And paragraph 5 minutes.
No, it is not there, sir. Sir, Ramesh Garu, don't insist the court for whatever you want to argue, but the rule is see post after
No, but then
we'll see after 4 weeks.
That's so true.
If you satisfied on that day, your case will be considered next appointment. We'll see on that day.
Can you pass any order? Understand? I am not.
Rule is see post after 4 weeks. Yes, yes. Become 19, 20. Read, yes. Applied, huh? Avara
They are not compared. In case of similar situated persons, they are compared.
Admit rule is post after 4 weeks.
Insufficient. Given the mission not to be petition, much time. Even the petitioner name and the other candidate called the Jitendra, both the case were rejection of our issue. In case of Jitendra, they had this honorable court that allowed the petition against the same interpret also fair, but interpret also the order of the compound. In case of other candidates, who are not,
Is it right?
fine,
Same applicable to you, this case or
Cases are different. He is involved in 3 cases. There only 1 case.
with regard to that also, I filed another document wherein The petitioner getting involved in the case, in minor cases, when he was in minor.
Okay, all the three matters post up for its rule is.
Level is the training schedule. This month level is not training schedule. Similar candidates are.
That is different, this is different. This is- He is 10 point, that is, there are only one criminal case.
With regard to that also, I have filed judgment, latest judgment also I have filed, but we very much clearly has that when there is a minor charge, when the petitioner can call minor case, they in the figure, it's our case concern. Insofar as the other can work more offences than the petitioner, even it was in murder case. In that case also, recently in the 2023, this government cancel case.
Counter is filed on,
Counter also filed with
criminal director is there,
the.
and that contempt is filed.
Application will not have the person.
The impact is there.
He said that training is going to commence on the September itself. That in that circumstance, it will not pass. Now my friend is again saying training is commencing from January.
Yes, interim they have
Said that training is going to commence.
training is coming.
You answer,
I correctly said, I also filed document also.
how you said that to get into the only.
I'm interim
At that time, training was only for civil
2
police.
days in the, this is going on.
It's not these
Okay,
are
you see,
these are different. I lost the
This
candidacy.
tax is interim order, that's all.
I'm filed contempt.
What contempt?
I'm filed contempt.
Again, you start now, you are asking, I am giving rule, let's see, post after police, then 11th is going to start.
Yes, I have filed document. I should kindly see the document and then I should kindly.
At that time, at that time, it is for civil, sub-inspector civil. He selected to AR. The training was on September 11th was for civil. He mentioned as his training is going to come day after tomorrow, he got interim order.
Correct, because before sending the training, they will investigate they will done verification of documents, they will send medical examination, all the process is there. I should kindly see the proceedings which are filed before your action on the day, clearly say that from 9 onwards, the proceedings were, the training proceedings were started with Langamasi. Insofar as
You file counter there.
No, I think the kids saying the immediately interim order. Not trying to take it up next week.
Next you will hear.
11, can you see 11 training should start.
Next week.
11 is started. Otherwise, you will not get done. 2011 matters. 2011 matters. Not the.
I'll give 2 actions. One is only see post after police.
Maybe password not see this. Last occasion, GP said he always matter on this date. That is why it took time. 3 occasions took time only for argument. Now we are seeking adjournment.
No, that the division order is one and not 100%.
No.
All evidence on-
But the last one is that similar order passed, similar order passed.
Second bench order is not that, that's a different, you are also sitting with the Honorable Justice Shabli on the order. But there, the case, there is only one single case. Okay. Now, the single case, when there are multiple cases, leverage.
Okay. Take up the matter for its, only see post after police.
I will pass on other senior computer. Someone available matter, but there is agency this matter. 2011 is suffering. Probably covered matter for the.
No, they have covered, don't say that.
Even that also one submission there. Can we see that? Let us Supreme Court judgment have can we see that very much this
Next week.
Next week.
11th is the training. 11th is the training. Can you pass out? Can you pass out? Agency is there.
Understand what is argument.
Agency is there. Why? Because the Ashok can see the additional document wherein I clearly said that.
The password.
It's a password.
Additional document can see that wherein this person who is
No, if anything, if I am not satisfied with that, your argument, I will post very fast. Okay, sir. This type of harassing the court again and again, once I am telling, post after 4 is rule lazy, we are not acting. And he requested next week, he filed a contempt vacate stay. Vacate stay pending is there. Even though you want to harass the court, tomorrow, agency.
only one submission is there.
Nothing. Okay, chapter tomorrow. If any chance day after tomorrow is not completed any arguments, we post the matter after 4 weeks, 2 weeks. Don't argue on that day. Advance I am telling to you. No submission. Next.
We apologize, right? Take it for registration.
Day after tomorrow.
Said that because
Who is the other side, madam? Who is the other side?
the original bundle line.
Yes, madam.
And not this repetition is filed by by a visually handicapped person. Handicapped woman, my lord, permanent disability. My lord, the certificate, your lordship will see, which is
Tell
a
me the facts, madam, first.
yes, ma'am. I'll just in a nutshell, my lord, the petitioner before your lordship is a visually handicapped. In pursuance to the notification,
Where is the notification?
notification is here, ma'am. Is at page. One. My lord, I'm sorry. 71, page 71. My lord, here, the trained graduate teachers in
71
residential.
is the notification.
Yes. And pursuant to this, my lord, the petitioner before your lordship has applied online, my lord. There was a screening test and after
Post
the
to apply. Which post you are applying?
to the teacher post.
So there are 5 posts are there.
In Hindi.
Which post serial number?
My lord, here, the post, the number of vacancies are given, but here, the, my lord, because here it's as it's a legal aid matter, I do not get the,
Spending more time on this. The union government also made a party.
but union government has made, but it is the relief which I am asking is against the respondent 1 and 2, my lord.
After for some time, you have
My-
got a lot of notice. Send the name of the legal.
My lord, that has nothing, no, my lord.
But it's made him.
It's okay. It is none of your concern.
Consider for the time.
My lord, your lordship may not take unnecessary pleas by the respondent who is very much interested in adjourning the matter. My lord, I will make my submission. In pursuant to the notification, the petitioner before your lordship has applied online and there was a screening test. After qualifying the screening test, there would be a main exam. She has qualified the screening test.
Where is it
and-
qualified? Name, document is issued.
Yes, I will, in a nutshell, I will show the documents, my lord. In a nutshell, I will. So after the screening test, she was qualified in the screening test and thereafter the main exam she has written and she passed in merit, my lord. And she was in the merit list, her number was there. And thereafter what happened? There was a verification of the documents, my lord. So she was called to the Hyderabad for verification. And accordingly, she came to Hyderabad. But in the meanwhile, in the train, she has lost her bag, in which cell phone was there. This is important because your lordship will see that after verification, she has said to the official verifying that because they take the registered mobile number in that form, I will show it. So in that she said, I have lost my mobile, so kindly take another number. Then they said, you give an application saying that this number, another number. So accordingly, I have given that number. Later on, what happened? That I was not called for the medical examination.
medical examination is only to confirm the deformity which has been stated by the petitioner is correct or not. Only to, although she has got the certificate that she is 100% blind, but they have to confirm that she has got that percentage of deformity or not. Only for that reason that medical test has to be done. So what happened was medical test, they have given SMS manner, and this SMS, this poor lady could not get that SMS. And they say what their contention for the honorable court is that the the candidates have to be vigilant. They have to follow the website. My lord, 100% visually handicapped has to follow the website vigilantly. That is what the respondents say, my lord. It is highly objectionable. But your lordship will kindly see this case is purely based upon the Act, that is the Rights of Persons with Disabilities Act 2016. This, I am highly relying upon this, and your lordship will kindly see that this Act has this Act is mandatory, my lord. This is in this the appropriate government is central state government as well as the central government, my lord.
So,
This is the central act, and here.
No, after act, madam.
Yes, yes. But
After this, what happened from your
yes,
side?
ma'am. Later on, what happened was after I did not receive any call for medical examination, then I have sent my brother, but they have not responded. Then afterwards, I went there and have given representation dated 19/7/2018 and 3/8/2018, my lord. Then for that, they have fully represented, fully given rejection letter saying that the recruitment has been concluded. Now there is nothing to be seen into, and you cannot be given any chance to attend the medical examination. My lord, your lordship will kindly see that accordingly, I filed a writ petition, WP 44411 of 2018, and accordingly, in that I have got an interim order dated 6/12/18, wherein I was asked to state my claims, and whether any vacancies are there or not. And accordingly, I have to give a representation, and and I should be considered subject to the medical examination. And accordingly, I have given a representation on 15/12. So after that, they have in the meanwhile they have not done anything, and thereafter they have rejected my application. They have rejected my representation, and they given rejection order dated 18/1/2019. And I filed a contempt case 554 of 2018.
In this case, huh?
In the WP 44411 of 2018.
What is that 44411 of 2000?
That was assailing the order of dated 6/9/18.
For the same post.
Same post.
Then what is your room?
That was against that rejection order. I'm just narrating, madam.
How many cases you find, madam? One post, how many cases you want to find?
I'm not pressing that case because in that after I filed the contempt case, the learned judge said that as they have considered and rejected your application, your representation, that rejection order you can assail. I'm closing this contempt case.
You challenge the order or not? You challenge that order?
Yes, that is the order before your lordship. That is the challenge.
That is the
Before your lordship. Yes, ma'am. Yes, ma'am. Lordship may kindly see 44/45, ma'am. Page 44/40. I'll just read to my lords.
Memo number so and so.
Yes, my lord. I'll just read, my lord. This is your lordship will see Kanta by so and so 15/12 representation in compliance with Honorable Court's order WP 4441 of 18 representation. Srimati J. Kanta by so and so, a VH candidate for recruitment to the post of TGT Hindi, is hereby informed that all the VH candidates who have attended for certificate verification for the post of TGT, here Hindi will come, and concerned with Hindi, my lord. By web notification, were directed to go for medical examination to be held from 4/4/18 to 9/4/18 without fail. Further, the candidates were sent individual SMS in this regard personally to their registered mobile number. It is to be noted here that all the PH candidates were informed at the time of the certificate verification process itself that they have to go for medical tests to confirm their deformity, and they will be informed the dates of their respective medical tests via the website and through sending message to their registered mobile numbers. It is the responsibility of the candidates to be more alert and vigilant in following the TSPSC website, since TSPSC cannot reach the candidates personally, and it is specifically mentioned in para 11 of the notification and a special instruction to candidates in this regard. The medical examination for the petitioner along with the 7 others were fixed on 9/4/18. As such, along with the petitioner, 7 others were sent SMS to attend for medical examination. However, except petitioner, all other candidates have attended for medical tests held on 9/4. It is informed that PH results of PGT were declared on 12/6/18 and the units were sent to unit officer on 26/6. It was also declared in the selection notification for PH candidates that the recruitment process notified by notification number 14/17 was concluded for the post of PGT with that result notification. Due to not attending to medical test by the petitioner, her candidature was not considered under PH quota. It is further informed that the petitioner has represented on 19/7/18 and 3/8/18 after the declaration of PH results on 12/6. In reply to representation, the TSPSC wide memo dated 6/9/18 has informed that PH results of TGT were already declared on 12/6 and the unit lists were sent to unit officer on 26/6/18. Hence, the request of the candidate to give her a chance to attend for medical board cannot be considered. However, in view of the interim orders of the Honorable Court, in WB 44411, the Commission has examined the matter and is of the opinion that it is not possible to reopen the recruitment already concluded, as it is contrary to GOMS 81, Department dated so and so, and as well as Rule 6 of the Commission rules. As per GOMS 81, dated so and so, there shall be no waiting list. Further, as per Rule 6 Commission rules, the followed vacancies, if any, due to relinquishment and non-joining of selected candidates shall be notified in the next recruitment. As such, the vacancies followed due to non-joining and unfilled in the recruitment notification for the post of TGT Hindi will be carried forward to the next recruitment notification to be issued by Telangana Residential, which is constituted under GOMS scheduled caste so and so. In view of the above, the candidate's request of candidate to give chance to medical board and to consider her candidature for the post of TGT by notification is not feasible for compliance. Your Lordship will kindly see. In this, the first thing is they say it is the deformity. My Lord, purely on the basis of whether she is medically, she is having the same deformity or not, that has to be checked. That's all. Nothing else. Then second,
you have received the message or not expressed?
I have lost my mobile and I have given.
When you informed them?
Informed them.
When? There is a proof. Show me the proof. When you informed to the extent you made a request, letter, etc.
But my Lord, yes, ma'am. That's what. Before, my Lord, before I answer your Lord.
From your side, you show me all right actions.
Yes, my Lord. I will answer that
Once
by example.
you now you forget about act, but show me all. No, not act. Show me. Give the proper answer to my question
Yes,
and another request.
Yes.
When you inform the department, your mobile.
I am informed on verification. Your Lordship will kindly see my verification was done on 29/11. Serial number 17, verification of document at Sanketya Vidya Bhavan, 29/11/17. So on that day, I have informed them that I have lost my.
What is the proof whether you informed or not?
I never thought that I would be asked.
You are trying for one employment.
Yes.
That is, mobile number is very important role will play.
Yes.
You are basing on message only you have to act upon.
Yes.
So for that, okay, we'll agree. We are usually challenged, accepted, but there should be proper action from your side.
But my lord, yes, what your lordship
Just
said.
informed.
No, what your lordship.
Informed what way you, how
Yes,
you
my lord,
informed
what
the
your
other.
lordship says will be, said person will be taken into consideration. If this act, if I was handicapped and if I was not having this act.
What access?
Yes, your lordship may kindly see rights of persons with disability. My lord, here your lordship has observed.
What right access?
Yes, I will. Yes, ma'am. I will just.
Tell me one line, nutshell. You are telling nutshell.
Yes, ma'am.
What is that?
In nutshell, I will say that section 34 reservation, my lord, reservation. Here it is said that I will say so many things, so many.
Oh, your
sections.
case is not rejected on the reservation. You are not,
Here, one of the.
you are not appeared for a medical examination.
My lord, medical examination, not a big thing, my lord. Whether your lordship has seen whether I have got deformity. If I don't have that 100% deformity, I will withdraw. My lord, I have got it. I have got the certificate of development. And still they want to just check. It's a common thing. But do they have?
You is a formal thing. For them, it's a mandatory. Everything to get employment.
It's mandatory, my lord. Whether the rules they say. But anyway, I'll answer your lordship's question, my lord. Section 34, 2, when it is said that if in any recruitment year, any vacancy cannot be filled up due to non-availability of a suitable person with benchmark disability or for any other sufficient reason, my lord, you have got the rights of persons with disability. My lord, your lordship may kindly see section 34 in that too, my lord. Section 34 too, my lord. Where in any lordship got it.
Yes.
Where in any recruitment year, any vacancy cannot be filled up due to non-availability of a suitable person with benchmark disability or for any other sufficient reasons. Such vacancies shall be carried forward in the succeeding recruitment year, and in the succeeding recruitment year also suitable person with benchmark disability is not available. It may first be filled by interchange among the 5 categories, and only when there is no person with disability available for the post in that year, the employer shall fill up the vacancy by appointment of a person other than a person with disability. My lord, here a person with here your lordship kindly see section 34 in that every appropriate government shall appoint in every government establishment not less than 4%.
Yes.
Yes, I will explain.
Here is not the question.
So here, my lord.
Here is not the question of your disability or your
Yes, I'll make myself.
disability. Question is that you are not attended this so examination. By that time, everything is over.
No, my lord.
That is the rejection order saying.
My lord may kindly see here what it is said that if a suitable person is not there.
Not suitable. What is your rejection order saying? There is no suitable person. That answer is there. That it is there in your rejection order. You are not a suitable person, and you are the not suitable person. This post is vacant. And your case is rejected.
That's what your lordship may kindly see. I'm receiving GOMS 81. Your lordship may kindly see. Your lordship may kindly see. GOMS the 45 page number. No, your lordship.
Answer on rejection order. Satisfy this court on rejection order.
In the rejection order, what they have said, this is against the GOMS 81.
That's what I am saying. You satisfy this court against the rejection order.
I'm explaining.
In another case, don't go for acts, etc. Nothing. It's a really cases.
That is mandatory, my lord. It's for
It's not saying it's not mandatory.
Yes,
It's mandatory.
yes.
For your case, if your everything is right, no need to go to for this act. This court itself will allow the repetition.
Here I have to go to this because they have committed violation. My lord, your lordship may kindly bear.
What violation they committed?
I'll explain.
What violation they committed?
They have committed the violation because your lordship will kindly see that these rights of persons with disabilities.
What?
Lordship will
You
kindly bear.
understand, madam?
Lordship will-
What I am telling you, understand?
Yes, ma'am.
Here the question is not the disability rights or acts, etc. They show satisfy this court basing on your rejection.
Yes, ma'am.
If wrongly they rejected your case, show me the fact. If then listen, madam. If wrongly your case is rejected by way of this rejection order, satisfy this code, we will allow the writ. Or otherwise, we close the writ.
No.
No need to go to acts, judgments, etc., etc. I'm ready to here to do justice for disability persons here.
Yes, my lord, this act.
I give 100% priority to them.
100%.
So now I am telling, in the basing of the rejection order, satisfy this court whether your rejection order was in a rightful manner or not.
It is not in rightful manner.
How you are telling that?
Yes, because here it is said, I will explain, my lord, the lordship may kindly bear with me.
Go for acts, etc.
My lord,
Basing
because
on this.
you have to, my lord, if the act applies, because I'm a disabled, 100% visually disabled person, whether this act is not for me, then it is for whom, my lord?
Again,
My lord,
always we are commenting negative comment. I am not saying this act is not applicable to you.
this act is helping me, my your lordship may kindly see, this act is mandatory because if any violation of this act is the penalty is there, section 89, your lordship may kindly see. But I will not go into that, but I will just.
How will I satisfy this court?
Yes, my lord,
Without
this one.
rejection order.
My lord, your lordship may kindly see. Your lordship may kindly see the definition under 2H, my lord. I will satisfy your lordship. 2H, my lord. Discrimination, my lord, act. Your lordship may kindly.
Yes, Rama.
Yes, we have, my lordship is right, pointed out we got. But this rejection order in table 45 and 46.
My question, this fourth question is that whether our own mobile
Has been lost.
place.
If we are in police complaint to that effect, and it has been brought to the public service commission notice within times that are lost.
We brought to the notice. We brought to the notice.
So that is to be established, that is one aspect. Due to this act, disabilities act, without or this, nobody disputing that. My lordship said, the rejection order was that we are not making time. Therefore, the next 2 years candidate, among the disabilities have been appointed. When the question of deviation of this act, that will be made up. We have to appreciate my friend Lord Slapping and we have taken the authority. And from that, Lord, I am very therefore, what is the illegality asking the impugn order?
Yes.
That is not my friend is able to establish, or my friend's client is not able to.
I can establish.
We got one more. The connector repetition number 411.
I'm not pressing that.
We are not pressing that. The Lordship Club will get that having tomorrow. Meanwhile, my friend may
No.
contact client of my friends regarding what time she has given or she has given. That may be get.
Something.
But you are reading the act. Who is this?
My lord, I'll establish, my lord.
Thereafter, thereafter, if lapses on your part, the recent judgment of Honorable Court is on the Nemalata was state of Tamil Nadu, followed by my lordship sitting with this government. My lords, get your fault, the candidate's fault, commission or UPS is not responsible. We are not feeling reaching within. The judgment is widely covered.
Is it for handicapped person?
It's for the commission.
My lord,
Commission
it's
is
not for
notification.
but handicapped persons, they are not normal persons, ma'am. We have to help them.
That
Why
is funded also handicapped ones.
why we are giving reservation? Why are we having these acts for scheduled class people and for this reservation for disabled persons? Because we have to help them, my lord, for that. But anyhow, my lord, I will establish my case, my lord. Your lordship will kindly go through this some of the definitions and provisions which will establish.
Sorry. You satisfy this court facing the rejection order. How far you are right, how far you are not. Why? Because already I said once, this court will give the utmost respect, priority, importance to the living personalities. Why? Because in my life, sometime I fight with disabilities rights. That's the reason I am also telling to you openly. Go with the proper reason after that. No need to go to any action.
My lord, your lordship will kindly see that here a person who has passed in merit list, my lord. Your lordship may kindly see she has passed in a merit list and she was not informed. My lord, They are saying that I have to establish that I have given letter, that they have not received the letter. They should also establish. So here, your lordship will have to see when there is no any evidence, then your lordship will kindly see the balance of convenience. My lord, your lordship will have to consider here, it's a visually handicapped person. She is a poor lady, visually handicapped person. In spite of her 100%, your lordship will see the certificate. 100% disability, my lord, visually handicapped, but she has passed her Hindi examination up till the top with one but thing, my lord. She has passed and she wanted to become a teacher, and she has worked hard, and it's not just receiving free of cost free money. She has worked hard and she has done Hindi examinations, and she wanted to become a teacher. And just because they have not given the they say that SMS will be sent. SMS any visually handicapped person can see. So, and I also strongly rely on section 27 of the General Clauses Act, whether service of notice. Here, the notice has to be served properly. Here, there is no proper service of notice. Your lordship will see that the examination, recruitment examination.
1 second. Okay, rule is see, admit post up to 4 weeks.
My lord, your lordship may give me interim order, say, let her go to the medical examination, my lord.
No.
Lordship may, because medical.
Ramgopal garu, Ramgopal, you forget about her arguments yesterday. You personally, from this court I am asking, she is a disability person number 1. And she is a qualified person number 2. Number 3, any chance to
Accommodating.
accommodate.
My friend is not coming to that point at all.
Any chance.
Vacancies are there. In the amount that they will be visually handicapped.
Being a visually challenged person.
Yes, ma'am.
She is coping up all the eligibility criteria.
Yes.
You should not lose this. We have to encourage this type of.
Yes, sir.
So kindly,
Any vacancies are
any vacancies are there? If vacancies not there, is there any chance to create for
there. Then
them?
we got GAD or consent department of that tribal justice rules are. Because we are.
First, we confirm whether the
Yeah, we
vacancies
check
are there.
I will they have just tomorrow, we got
We should
along
not
with another petition.
neglect this person
Yes.
because they are on the way. They are qualified. Okay, we believe they are also respecting your system, giving messages to her. Nowadays, disability persons also more than perfect than regular person.
Yes.
They are using
Yes.
mobile in like anything. Why? Because all facilities are there in a
She's in a remote village, Nidwa, madam. She is with her old mother, about 80 years. She is just surviving, just.
They have to come and get instructions, sir. We'll see.
Along with that, other candidate petition. Level 411.
Only say they have to tomorrow.
Level 411 of 2000. The
Really,
same petition, that can be.
But, your lordship will kindly see that there
Not to
are.
some other government.
There are
1 second, madam.
Yes,
Once court is in favor, you don't
I'm
argue.
obliged. I'm highly obliged.
I'm asking, I'm requesting the court.
I'm highly obliged, my lord.
If there any chance is there,
If I
accommodate.
can get the job, my lord, it is enough. Nothing else, because
Post along with the number of triple four,
411 now.
11 of 2018.
they have to tomorrow.
Yes.
Kindly get in instructions, sir. If it is availability is there, we'll accommodate.
Okay.
But get in a positive manner. That's
Your vacancy level to put in.
Huh?
That is the department.
We don't give usual answer, just do.
We are do, I'll ask.
Article,
Talk to the secretary itself, if any chances are there.
Highly obliged.
Item proceed to Ram Gopal Rao, VP for services to.
item,
Proceed to.
post after
2 weeks.
2 weeks.
Item proceed to take care of my VP for police station services.
Count is not right, yeah?
On that last occasion, the lordship heard this matter. In that, the transfer case of NCCR,
Next case.
the lordship had asked me to close. But, that's the material to show that the non-NCC officers have been posted to NCC schools. That's what you lot to pass. Now, Lord, we have to list that already that issued allotment letters that in the counseling. That these are all the non-NCC officers that posted. That you want to kindly take up at page 37 of the material kept in the petition. Then side by side that we compare this also, so that you will not get that page. Page 37. This is an option form supplied to the NCC officers by the DUO itself.
Page numbers.
37.
Up to 25 page numbers are there. 25 no revision. And 36. Okay.
37.
So on that day I asked you questions, sir. Your number is serial number 11.
Yes.
Reference number 11 compulsory mate chain is given.
Yes.
So what I am asking from you said, sir, right from 1 to 10.
Yes.
Who are the posting or issued? They are less than you or greater than you?
No. They are non-NCC officers.
Okay.
They are non-NCC officers.
And from your side also, your priority also is this 11th post.
Yes.
You are given priority for the 11th post also. 11th, yes.
No, but what?
Even though you are questioning, once you are accepted, you put a option.
20 options form, 20 option forms blood submitted, blood issued by the DEO, and blood on that blood I submitted 20 options. Preferences 20 because I have to give 20
So
options.
what it means? So
20.
availability, basing on the availability, transfer, right from 1 to 20 options, they can accommodate you any out of 1 to 20. Right? If I am not wrong. You given options 1 to 20, sir.
1 to 20 I have given that.
So,
But
if you are giving options 1 to 20,
is not very
you are giving options 1 to 20.
Yes.
If you are giving options 1 to 20, if they are not going, they are going to accommodate you after 21, you can question. They are within
Within the 20 also, not within the 20
so
also.
within the 20, as per your request, as per your demand,
That's true.
within the 20, they accommodated you.
Within 20,
My question is, number one, what is wrong in it, number one.
Yes.
And number two, you raised, if anybody was transferred before 1 to 10, 1 to 10, priority wise, if they are NCC teachers or not, or NCC area, that school is have the NCC area or not.
These are all NCC, not schools.
Yes, so 1
These
to
are all NCC schools. But posted blood not
11th school, 11th point, 11th item number 11 also the NCC school.
That's true.
Then
No. Here is a point is blood lots. My grievance is that so far as teacher transfers are concerned, governed by a statutory rules. Statutory rules, blood, just like rule framing blood provision to 309. These are all blood rules, blood framed under blood exercising the rule making power under blood section 78 and 99 and 309. Page 13 your lordship effect.
Page
13 blood 13. GOMS 16 blood. This is called as
These rules shall be called as Telangana Teachers Regulation of Transfers Rules 2018. Lordship got blood title and applicability.
Today is last day, sir. In this matter, we have to finalize. Is there you have to satisfy.
That's what.
Challenge.
Not this GO. Not this 16.
Evidence, show me evidence. Okay, pass out. If it is under challenge, we'll post the matter of police. We'll admit and post the matter of police. Pass out.
I think well under the last application is
If it is wrong, we will hear the matter after lunch.
no challenge.
If it is challenge, how can we decide on that issue? On that issue, how can we take a decision?
No, these are all transfers affected. But 2018.
Get in suspended.
No, one submission. Holding blood said posted saying something blood.
No, we are not like that. We are asking him to produce evidence.
Whether it is relevant or not. Rules are framed.
Your 16 is under challenge, sir.
No, one submission. There are two aspects. 2018, these rules are framed. 18 transfers are affected. There was no challenge. Now, blood in 23 again, blood transfer policy was made. Blood as per these rules only. Now rules have been challenged. How I am affected blood? My grievance is as on 2018, not as on 2023.
You are a senior counsel, no need to say anything from my side. Once one rule is challenged, one GO is challenged. Once challenge, if it is there, can you take any decision under the same GO?
2018, there was no challenge. There was no challenge at all.
Can we take?
There was no. That's what your lordship has
Once
to
it is
see.
a challenge, it is not a
No,
challenge.
lordship has to see.
Maybe you are right.
2018,
Maybe you are right. On that day it is not there, but now today it is under challenge. Once it is under challenge, can we take any decision against that GO or throw it to the GO?
My case is not. It goes back 2018.
I am not saying anything, sir. You are right.
That day it was not under
You are
challenge.
200% right. Now we are going to take a decision.
Lordship sitting under 226 and examine whether there is any illegality committed, blood violated the rule as on that day.
No, sir.
Suppose blood if your lordship.
So, while I am requesting you, sir, being a senior counsel, I have a zero knowledge. I am asking you one question. Once the GO is under challenge, any court can take any pro or negative decisions against the GO.
When it is challenged, my amendment is not.
That's what I am asking. Produce evidence.
No, when it is challenged, only 2023 it is challenged.
Madam,
2023
take it
council.
after lunch.
Yes, blood.
If it is only chance,
I know that 2023 counseling, that rule has been challenged by somebody else. We don't know that. It will go to the division bench. So far as challenging the statutory rules. So 2018 it is challenged, 2023 it is challenged, madam, you tell me to the court.
okay, pass on.
That she would have told long back. Another math was there. I am sitting here only for this.
If it is not correct, I will accommodate you tomorrow, sir. Don't worry. We don't want to waste your valuable time like your senior counsel.
No, batch is there, LIC matter. So let you inform.
Madam, get in touch immediately. Whether it is challenge or not. 24 and 25. AK for services. 24 and 25. 24, 25. Services fund. Okay, post after 2 weeks. Item 46. TH Ganesh, DP for education. Yes. What, Mr. Ganesh? Who is other side? Okay, post after 2 weeks for counter finally. You admit it, Asani? You'll admit rule is post after 4 weeks. Finally, rule is post after 4 weeks. Meanwhile, contrast to file, madam.
Yes.
Don't take advantage. Rule file contract. Second, 37, AWS selection. Plus, okay, this is also not even admitted. Rule missing post after 4 weeks. Yes, next. Basic action we have to complete. Item 48, Ramarao. Okay, this is also not even admitted. Rule missing post after 4 weeks. Item 39, urgent. Item 30, page 7, down. This is also rule missing post after 4 weeks. Item 31, Kiran Palakot peak. On freezer. This is also not even admitted. Rule is post after 4 weeks. Item 34, Kim Miller. Item 33, Ravinder, Lakote, Secret Post Services.
Government study something like a granted relief. And issued a memo that most of the same this can close and in practice.
The council for the institution and reform this court. Your good name, sir?
Ramesh.
So Ramesh representing Ravindra Alakochi. Matter becomes instructions. India that are
India government memo.
government memo dated.
Memo dated 13/7/2020.
Thank you. Item 34. You give it to the geo copy to madam. Krishna. Item 34. Next is what? So you also take relax.
Unless it's not that cheap, because it's the answer.
What is that matter about?
Benefits of that disease.
This is also rule is post after 4 weeks. Are you admitted?
Because it's the senior citizen, but the father of the particular patient.
These 2019 matters, sir. First you have to complete basic steps. Without admitting years together, going on, what is this? Okay, post. Within no time it will come.
Propose the study.
I will file the.
Again, you have to send the proposal to the, then they will be out.
I will file the test.
Okay, take action, that also. Rule is post after 4 weeks. Yes. Item 45. Post after 4 weeks. Item 36, Then Praveen reading. In the name of Tom Srilas in place of N. Praveen Reddy, rule is post after 4 weeks. Yes. Item 37, big up. We are sure. This is also not perfect. Okay, rule is post after 4 weeks. Tower, not tower. Item 38, MR driver, Secret Post Services.
You can receive from unofficial response.
Okay, rule is post after 4 weeks.
Finding replies.
Okay, you file the reply will take up 4 weeks after 4 weeks.
We filed it last Monday.
Complete steps are. How many years you print admission?
They filed the last week.
Okay, we'll admit next time it will come interactive. That's all. Your cases will be over on that day. Okay, rule is post after 4 weeks. Ram Gopal Rao.
Out of time.
Rule is post after 4 weeks. PT Acharya or become 40 KP Acharya.
This is the case, my lord. Detective, they are objections of the applicant. And the respondents can be placed above her, contrary to the judgment of the Supreme Court. Not required, by my reply also.
Okay, rule is post on 4 weeks. Finally,
She is being harassed every day because he is posted above her. Now,
no, madam, no, sir. Since 4 weeks, it will come as usual immediately.
since 2020, we are trying for posting this.
Yes, today we are just completing second step. Be happy for that. We are admitting your case and post on 4 weeks.
Already count is filed.
Okay, take up after 4 weeks. If my bench will continue, after 4 weeks, finally will take. Don't worry about it.
No, if you accept benches in other than by petition for getting posted this.
No, it will come. Yes, next.
Instead of 4 weeks, some started because already
All
count is filed.
4 weeks is for you. You are a senior counsel. In every rule is it minimum 4 weeks we give. Courts will grant. And one step they have completed today.
On specific date may be given.
Yes, date.
Court to it. Court to it. Court to this.
Become 41. Ask for mark P.
You know, I'm responding to your please. I'm going to respond and we are already.
There is P. Rajkumar.
You know, I'm appealing on behalf of my senior.
Within servants.
Hello, actually, we have already stated citation. The petitioner seeks recognition in the LIC corporation. But as per the Honorable Supreme Court order.
Oh, some of the people, the LIC corporation. Next week, post of 2 weeks session.
No, madam, that matter is different. Morning, Ramgopal sir was.
Okay, man, now petitioner calls the option post of 2 weeks.
They post for dismissal.
Why?
But the petition is not elected since several occasions.
That day he'll come and remove from this visa next.
For orders, madam.
Nothing. Become 40%. Let's do that. Let's do that. Yes. As for the petitioner, madam, you are for the petitioner.
Yes, sir.
Yes.
Adoption matter pertaining to the notice of promotion of the petitioner was retired as the permanent grade 2. Pertaining to the promotion of.
What once retired, where is the question again? Already retired from service. Others more.
The lordship, the petitioner was fully eligible candidate for the notice of promotion.
Before promotion, already retired from service.
While the service only she was eligible for the promotion.
No, now it is he is retired, madam. What can we do? For what? Benefits, sir.
Yes, the lordship. The lordship, my kind of.
The retirement only, the speaking orders are passed on to 2014. After retirement, he has challenged this matter. They have rejected saying that cannot be given motion promotion compared to the official response.
But related kind of challenge, right?
Yes, that's challenge.
The
It is
lordship.
restricted, huh?
Yes, 28/4/2014.
Lordships have given many representations to the respondent authorities. The respondent authorities have rejected the representation stating that they have not completed the period of 3 years. But as per the government GO number 627 of 1983.
All is also not points.
Committee not well. Okay. Admit and admit type is right, madam?
The lordship, this is the counter the lordships.
No, madam.
Already admitted.
If you don't want to counter, we'll dismiss the case today itself. Because number one, we are retired from service. And basing on your representation, your case is already rejected. Now, if I am want to say anything in favor of you, we are not in service. Happens more in this case.
Lordship, the petition has taken steps while the service only.
Correct, madam. Now he is retired from service. And basing on your request only, your case is considered rejection order is passed. By that time you are retired from service. What can we do?
Grade 1 promotion, whether she has to complete the 3 years of service in grade 2 for valid 13/14. She admitted she is not completed.
The lordship, my kindly see the respondent accepted the petition on call. B. Shanta Kumari. She has not even completed a period of 2 years. Only she has completed 2.
What she is saying is right, sir? What she is
Not at all for that.
file your counter, want to be counter, file your counter post after 2 weeks.
Set of 43, we know some of those.
Take out notice, we are watching. Take out notice, we are watching. Effect has not been on.
Await notice, huh?
We are watching. There is no appeal in the third that we have taken notice. You are not sure. The watching may grant is to take steps, and the commission to take steps for public paper publication.
Okay. Direct the petitioner counsel, you file IA. To that extent, you file IA, will allow IA, giving permission to paper publication.
Expect your motion.
Item 44, Rajan Miller. Item 45, Rashekar Reddy saying. Thank you for police status.
You ever said? Counter not filed? Sir, who is appearing? Counter filed, very good. You serve the counter to him and take up the matter next week. Okay, post after 2 weeks. Serve counter madam to him.
Item 46, Rajan Miller. Item 47, Prabhakar Chukula.
Matter pertains to the declaration of the service law, therefore yesterday is something what we mentioned. Similar matter, finally to file the counter by the respondent. The last may post along with that by directing a file the counter finally. Because in the year 2018, this has been filed. Since then,
Post after 2 weeks for counter.
yes,
Along with post along with
40587 of 2018. WP number 40587 of 2018.
okay. Post after who has to file counter?
Execution funding council for beverage corporation.
Prepare madam.
5 years over.
2 weeks is enough. Not more than that, less than that. 2 weeks is enough.
Already 6 years over. If you want to time, they can take 2 more weeks.
No,
Finally, maybe.
no, you have to appreciate her. She is not asking. I am asking, you want less than that or more than that? She is saying. Okay, 2 years. You have to appreciate her. Yes, sir.
At least 7 years service completed in commissioners. They must not recognize the service. That is
Madam, you file counter within 2 weeks.
finally, maybe.
Finally. You post along with that referee number also.
WP number 40587 of 2018.
Item 48, Srinivas Rao Madhuraji. Deputy for police station.
Yes, for next week, madam.
Post after 2 weeks.
Item 49, K. Sriram. Deputy for labor. Narasimha Road.
Give the name of Mr. V. Narasimha Gaur. Issue notice to the respondents. Madam? Okay, we'll issue notice to the respondents. Should, huh? Okay, delete the name of the Narasimha Gaur. Post the matter after 2 weeks.
Wait, notice.
Wait.
Item 50, M. V. Ramarao. Deputy for social minister. 3 Umbrella.
3 months time, for what? 3 weeks. Okay, 3 weeks, post after 3 weeks.
Thank you. Item 51, yes, Amit Kumar Reddy. Very Praveen Kumar. Yes, Amit Kumar Reddy.
Yes, yes. Amit Kumar Reddy. Petitioner counsel absent, post after 2 weeks.
Item 54, Rajan Miller. Item 53, Venkat Mayor, D. Vasudeva Reddy, M.
Whether it is appearing or somebody.
Somebody saying,
Who is appearing, sir? You are appearing. In case of any Vasudeva, who is appearing, anybody knows? Or Hyderabad? So now it is 53 is going on, sir.
53, sir. Venkat Mayor.
Okay, director is to fill the name of two students post up to 1 week.
Item 54, Ajay Miller. Item 55 and 56. Ramasharan Sharma. JAD. TV Ramana.
I filed implement petition.
Yes, sir.
I filed implement petition.
You implemented, sir.
Petition number 9.
Item 53, 55, 56. Sir.
Item 55, 56 called, sir. Okay, none of this post after 2 weeks.
Item 57, Great Vasulu. 55 education.
Some parts of my senior is going to appear in this. Okay, cover on the. We can copy.
Award and in favor of them or against?
Single person.
That is the same order, madam.
Yes, yes. Yes, ma'am. Constitution is a house. But petition transfer from the APA to madam. Yes, yes, 4658 of 2017.
Okay, pass over. Pass over.
Item 58, Shamsan Babu. CH. 55.
I'm representing Mr. C.H. Ramesh Babu, your lordship. Today his father's ceremony is there. He requested the time but post and healthy, your lordship. He took the lordship.
Post after 2 weeks.
No, your lordship. He requested already, your lordship.
10th, okay, post and 10th.
Item 59, Shetty Ram Mohan. Desha Prakash Niranjan Reddy.
Post after 1 week.
Item 60, K. Devendra. Civil Development.
None of this post after 1 week.
Item 61, Bedam Srinivas. Wait,
Right from this post after 2 weeks.
Item 62, Rangaraju Rajshekar Rao. Panchayat Raj.
Suspension 2018.
Post after 1 week.
Item 63, Baldamesh Cotton.
Ready, both sides ready? Both sides ready?
Asking for respondent. Start on the last second for there is a repetition of data to make it. That's a certain statement for us. It takes some time.
Because I have to go through the judgments. I bring the latest judgment which the council has appeared in the case.
Repetition is major and starting to do.
The judgments which is rendered by the respondent council below, those judgments are not related to my case. It is not applicable to my case also. Those judgments which has been filed by the respondents,
Counter is filed, huh?
counter has been filed, but they have raised an objection in their counter that even the objection, it is not maintainable. And even though
Not maintainable. What is the question they raise?
question, the petitioner before your lordship is an employee in Cooperative Center Bank Limited, which is governed by under bylaws, and basing on that, they have stated in their counter after lapse of 3 years, they are saying that it is not maintainable. That is belated stage they have raised their objection in their counter.
Deleted state are not.
State are not. Those questions were
By the bylaws or any government GOs rules, etc.
they have governed by the bylaws.
Then, read.
In bylaws, you know, kindly see.
Where is the matter?
That is, no, my lord, kindly, hear my argument, not then pass orders are made.
Must satisfy in that area.
Yes, my lord. Lord, petitioner before your lordship is an employee working under respondent cooperative center bank limited. Initially, he was removed. On the basis of that, he is not seeing the checks. You know, what happened in the respondent cooperative center bank is one customer, Milord, who has overwriting the checks. Basing on that, Milord, he was removed because checks were not seen by the, he is only as a clerk is working in the respondent cooperative center bank. The main, the checks who has passed by the manager, they have not taken any action against them. He has only taken action against these persons and the inquiry was conducted before the cooperative society. You know, the officer was engaged on that aspect under section 60 of class 1 of Cooperative Societies Act. Inquiry was conducted saying that it has to be dissolved and separate action has to be taken against the N. Shankaraya, who was the customer of the respondent cooperative center bank. Separate action has to be taken.
The issue, whether it is maintainable or not.
That is what I'm going to bring the facts. Subsequently, he was removed. He has filed a writ petition before the Honorable Court. Honorable Court says that there is an appeal provision is available. Please go
Appeal.
appeal. After he went for appeal, they have reinstated into service and the amount which was fraud made by the customer between the bank manager, the entire burden is given to this clerk. And basing on that, they are saying that no, you have to pay 1,62,000. Basing on that, again he has approached the Honorable High Court. Honorable High Court says that you pay 1 lakh. And while they have not choose to file in the counter and 24532 of 5. In that case, new facts has come. The council was appearing in that writ petition on behalf of the present writ petitioner, saying that new facts has come. So we have to pursue that remedy. Subsequently, the Honorable Court says that please, new facts has come. You file an application before the cooperative center bank. Subsequently, the respondent, the petitioner before the lordship, he was retired from services in the year 2015. He made a representation saying that my benefits are holding with you. Kindly consider my application.
What is the representation?
They have passed an order on that below. The representation I have not filed, but basing on my representation, kindly see the page number 14. The order which has been filed by the respondent central bank.
This is the improved order. This
This is the improved order which stand before your lordship.
What they saying that?
They are saying that simply they are not giving any filing, simply passing that he is involved in other cases. That's why we are not considered. Kindly see, kindly see the page number 14 below, the references in serial number 3. Sri M. Mallaya, retired manager, appeal dated. This is the appeal which he has preferred. On dated 8/11/2017. Basing on that, they have passed this proceedings. That is 31/7/2018. The was which they have issued a proceedings below. Kindly I may permit to read below. M. Mallaya, retired manager, submitted a representation dated. Page number 14 of the merit petition. Sri M. Mallaya, retired manager, submitted a representation dated 8/11/2017, which was received by the bank on 9/11/2017, wherein he has sought the release of 5 annual grade increments, treating the period from 28/7/2004 to 15/4/2005 as an duty and payment of salary, treating the suspension period from 25/5/2012 to 11/1/2013 as an duty and payment of salary. Refund of rupees 2,253,000 kept under sundry account. Refund of rupees 1 lakh deposited. payment of interest on gratuity for the delay period from 1/11/2013 to 28/6/2015. The above representation was made by him in pursuant to the passed by the Honorable High Court. In WP number 24532 of 2005, dated 18/9/2017, the said representation has been placed before the board and the board thoroughly verifying the records, keeping the previous proceedings issued by the bank, rejected the representation of the retired employee as without any substance. The reason for rejecting the representation are as follows. Sri M. Mallaya was inflicted with the punishment of stoppage of 5 annual grade increments with cumulative effect, treating the period of dismissal as leave to the extent of eligibility and remaining period as leave on loss of pay. Remittance of half of the amount of rupees 3,25,500, rupees 1,62,250 with interest at the rate of 18% per annum. Reinstatement will be made after remittance of the amount. This punishment was imposed by the committee by its resolution dated 4/10/2005 on considering his appeal, challenging the dismissal order and recovery proceedings dated 28/7/2004. The said proceedings become final and stands hold good even though Sri M. Mallaya filed WP 24532 of 2005 challenging the said proceedings. He has not obtained any orders from the Honorable High Court setting aside the above orders. The Honorable High Court disposed of the above petition on 18/9/2017, permitting the petitioner to submit a representation to the bank, bringing to the notice of the bank about the subsequent events which took place after filing the petition. The contention of Sri M. Mallaya is that the Joint Minister DCO, in proceedings dated 23/11/2009, dropped the surcharge proceedings against him. In view of the dropping of surcharges proceedings, fixing the liability on him to the extent of rupees 1,62,050 by the bank is automatically goes and he is not liable to pay any amount. Such a contention of the retired employee is untenable in the face of finalization of disciplinary proceedings by the board. Such as proceedings are different and disciplinary proceedings are different. The result in one proceeding has no bearing on the other. Then the contention of the retired employee for a refund of rupees 2,253 as well as the deposit amount of rupees 1 lakh as per court order is rejected by the board. The release of 5 annual grade increments also will not arise in view of finalization of the disciplinary proceedings against him. Likewise, the payment of salary from 28/7/2004 to 15/12/2005 also will not arise as the employee was under suspension during that period and that he was paid the subsistence allowance and said period was treated on leave for which he is eligible and whatever amount payable to him was settled by proceedings dated 31/10/2005. The salary for the period from 28/2004 to 15/12/2005 amounting to 1,155,000 was paid to his SBI account on 23/4/2018. Hence, the contention of the retired employee in this regard will not hold good. Insofar as payment of salary as well as subsistence allowance during the period from 25/5/2012 to 11/1/2013 is concerned, he was paid with the subsistence allowance and subsequently the punishment order dated 3/2/2015 was passed, imposing penalty of 5,000. In view of the punishment order, he is not entitled for any salary during that period as he is not having leave balance to his credit. The contention of the retired employee that he should be paid interest on gratuity for the period covering from 1/11/2013 to 28/6/2015 is untenable and incorrect. The retired employee has been involved in several misappropriation cases and he initiated several legal proceedings which caused a delay in payment of the gratuity amount. In view of the several proceedings which has been pending against him, the bank has paid the gratuity amount to him which has been received by him without any protest. The delay, if any, is on the part of the retired employee, but not on the part of the bank. Hence, he is not entitled for any interest for the agreed delay period. The committee has thoroughly considered all the above aspects, which material available and rejected the representation of the retired employee. The below Chief Executive Officer has passed this order. He is an appellate authority. Agreed this order, no authority is there as per their bylaws. So he has come under 226. The judgments which are below,
Says so.
you know,
Bylaws say so.
bylaws is there.
Bylaws says Once the appellate authority passed the order, it is questionable in the Article 226 or any.
Nothing it has stated. I will bring your lordship the bylaws which they have stated. I will produce this kindly.
No, you raised this thing.
Because
You are saying something means this is the appellate order, final order.
final order.
After this, there is no.
No authority is there.
Then is there any direction in the bylaws? What is the route to if we are not satisfied with the appellate order, where we have to go?
That is not there. That
Yes,
is
sir.
for the lordship. Kindly see this, their own.
They are not satisfied with the appellate order, where they have to go?
There are several remedies available to the petitioner.
Not utilized, huh?
Remedy is approaching the registrar of waiver, materials of the otherwise there are the labor.
Soon.
Declaration as per
These three things are there in the bylaws.
bylaws may not only say how department inquiry has to be conducted. You will conduct the department inquiry, you will file the punishment on that. Who is the operator? Then people are where they have to go will not be mentioned in only in our bank bylaws. Bylaws can not service regulation. Not even the such regulation. Even in the state government, tax government also.
You can go to labor court now, madam.
So one submission, he is not a labor. First of all, it is a cooperative center bank, employee and employee relationship. Is nowhere they are mentioned in their proceedings of
Discuss the employer relationship.
No?
Labor court will decide the employer discussion.
Yes, Lord, but that too after belated stage, they have not taken this plea in previous petitions also. Continuously, this honorable latest judgment who is appearing in that petition also, they have said that it is not paintable because it is not a state. So, basing on that, the latest judgment which has passed on before the lordship is, they have filed all those citations.
Parsivala. Justice Parsivala.
No, not that one, just now I have given latest A&E passed by the honorable judge of this honorable court.
23
A&E, latest, they himself appeared, they have raised all these objections in this writ petition also. We are not coming before our lordship is on the basis of removal. We are only seeking for benefits, which is entitled. Even though their bylaws is also not stated that where we have to go. Several repetitions were filing before this honorable court when they have not choose to file counters after lapse of 3 years after United States. In this they have filed that too after 3 years. They shown that they could have raised this objection, this positive time will not be taken in that because he is a senior citizen. Since he is fighting since 2004 onwards, even though there is no mistake on the part of the employee.
What is wrong in the rejection order?
Rejection order is
31/7/2008.
Such as proceeding clearly, kindly see, I filed in the writ petition also. The inquiry officer, what he has taken the action against these employees also. Kindly taken up, such as proceedings first, kindly see,
What is it, the 24532 of why you find this petition?
on the basis of removal.
What is the answer said? Court below?
They have, in that writ petition, which previously they have filed. 24325. What was also. 17th page below, my writ petition. Previously, which the present writ petition has filed. Writ petition, kindly see page number 17 for the book and book. In paragraph 2, while admitting the writ petition on 17/11/2005, this court passed the following interim order in WPMP number 31536 of 2005.
This is third round of litigation.
No?
This is third round of litigation, according to you. First is 24532 of 2005.
5.
And the another one is 31536 of 2005. Now the present case.
Present writ petition.
Third round of.
third round of litigation, they never taken those, the present plea which they have raised, which is not maintainable. They have not choose to raise the objection also in court discussion.
You forget about the maintainability.
Humanitarian law, it has to be considered.
Yes.
There are one of my counters.
Yes.
They put it in.
Which para? Which para? Which para in the law? Huh?
Para one.
Oh.
The other reputation is the public bank is not better than the law. And it is not a state of institution, not a state of institution. And the consideration of the rest must be that you are not raised such a plea, even in the earlier reputation. In every reputation, my lord, you have taken such a contention. However, my lord, those reputations, etc., I guess it was the admission change, condition given by a council that will refer the I will submit a representation. Even coming to the merits also, my lord, there is no place for reputation. First of all, my lord, we submitted the full-page decision to your lordship. Because the maintainability, that is full-page.
Lord, that judgment is not against the removal, my lord. Removal, it is not maintainable, it is only representation. Different.
My lord, different, my lord, I have done it. Different causes, my lord, wasn't different place. But after the justice, reputation 4452 of 2004. After the submitted decision to come.
Oh, it's going to the number.
It is the very same bank. I think that is the problem something that. They will say, order of the rest.
Very same branch, yeah? Very same branch.
Very same bank.
Oh, yes.
You have decision of the bench of for same of corporate bank instead. And the decision of the Supreme Court and government bank instead. The reputation seeking resolution of a dispute related to services of the petitioner in the respondent corporate bank is not maintainable. Reputation is arranged with liberty to pursue appropriate business.
Yes, what is it?
Kindly see,
Apart from that, later following the same different method, another thing is that the standard before also discussed very much. Full bench but of the honorable court. And again, the very same government 30 banks. I think all of them are here. All.
Have you seen this latest one?
I'm not, just now, yes. You know, one
30.
one submission I want to bring your lordship is, they have produced this judgment, kindly see the repetition prayer of the Justice Goran Agrawal, kindly see the prayer of the repetition. The petition is under Article 226 of the Constitution, praying that in the circumstances stated in affidavit hearing, the High Court will be pleased to issue writ order direction more in the nature of the writ of certiorari, calling for the record relating to impugn proceedings number so and so, consequential memo number so and so, quite the same by holding them as illegal, bad and arbitrary. You know, in this, they have removed. On that basis, the memo has been issued. My prayer is only after appeal, I have approached the appeals authority. Thereafter, I come before our lordship under 3.6, you know, to consider the representation.
It will not be any difference. With regard to the removal, dismissal, or any other service matter. With regard to promotion, etc., CDI and thing. There is this. The reputation is maintainable and consistent. Cooperative bank is not a state with the control of the article 220. Article 12. Because this cooperative bank is not receiving any monetary payments from the government. Government is not having any control over the bank. That it is doing its own business, business. No board of directors are there from the government family, only one registrar is there without any voting right. And no control is there. Apart from that, section 115T also, 2002 amendment here, cooperative banks are autonomous bodies. They should not function autonomously, subject to directives to be issued by the RBI or non-bodies. No, the government has no capital investment in lands. As per that, its bylaws or its service regulations are only contracted in nature. So no reputation of asking. As per that, it's only that. Simply check categorically stated for find the student system, place to work, year 1990, Andhra Pradesh, 171.
It is not there. Not there. No.
Page 4. Student system. Year 1990, Andhra Pradesh, one page,
Have you
171.
seen this, madam?
I've gone to the.
The very corporate logic is say, Colasima Cooperative Central Bank Limited. That is also Cooperative Central Bank Limited. Now that the Colasima name has been changed and needs to go on district cooperative. But in that very lengthy judgment, para 41. After discussing all the issues about Christian, referring to various common and other inputs. 41. It says 32 minutes.
This is
Applying the above test, the appellate society is cannot be part of public body. It has no duty towards public. Its duty is towards its members only. It has no power to take any action or pass any order affecting the rights of members of the public. The binding nature of its orders and actions is respect to its members and to its employees. It is neither a statutory body nor are its relations with its employees governed by a statute. Functions are also not immediately a governmental function, nor is it is a case where it can be said that the reality behind the society is the executive power of the state. Moreover, even if for some distant reason it can be characterized as a public body, even so that contract of public utility at a reputational cannot be treated as belonging to a public law field. It is a pure and simple contract of service, and there is no statutory provisions regulating circumscribing or governing this relationship, except in section 47 of the English of the Establishment Act, which imposes certain restrictions to a matter of termination of service of the employees of the this aspect which is considered present case. Therefore, in conclusion, it made a 61 summary in 36. The above discussion, the following conclusions emerge. In that paragraph,
51.
51 para. Columns are there. Third class. The bylaws of the cooperative society registered under the AP Cooperative Society Act do not have the force of law. They are the nature of a contract. Terms of contract between society and its employees or between society and its members, as the case may be. Hence, where a society cannot be characterized as a state, the service conditions of its employees governed by bylaws cannot be enforced to a reputation. However, in the matter of immaterial which are not the duty tax such as capital. So unless that statutory provision has been violated by the cooperative society, cooperative bank, no reputation lies. That my lord. There are page number 40. This Supreme Court decision regarding Federal Bank for the Saga Thomas, relevant provisions paragraph 25. Paragraph 25, page 16. Paragraph 25. A company registered in the Companies Act for the purpose of carrying a credit trade or business with private enterprise to earn livelihood and to make profits out of such activities. Banking is also a kind of profession and a commercial activity. The primary motive behind it, and well, we said, to earn returns and profit. Since that moment, the activities are being carried out by the individual company. It is a private employer of the company. So, case of nationalized bank stands are different to me. They are well, they may well be companies in which majority of state capital will be contributed out of the state funds. And in the view of the matter, there may be more participation or dominant participation of the state in managing the affairs of the company. But in the present case, we are concerned with a banking company which has its own resources to raise funds without any contribution of shareholding of the state. It has its own board of directors elected by shareholders. It works like any other private company in the banking business, having no monopoly status at all. Any company carrying on a banking business with a capital of 5 lakhs will become a scheduled bank. All the same banking activity as a whole, carried out by various banks undoubtedly has an impact and effect on the economy of the country in general. Money of the shareholders and depositors in such companies carrying on the banking activities. The banks finance the borrowers on any given rate of interest at a particular time. The advance loans and other securities. Therefore, it is obviously necessary to have regulatory check over such activities in the interest of the company itself. The shareholders, the depositors, as well as the maintain proper financial equilibrium for the national economy. The banking companies have not been set up for the purpose of building economy of the state, and the grants of private companies have been marginally established for their own purposes and interest, but their activities are kept under check so that their activities cannot go wayward and harm the economy in general. A private banking company with all freedom that it has to act in matter that it may not be in conflict with or against the fiscal policy of the state, and for that purpose guidelines are provided by the Reserve Bank so that a proper fiscal discipline to protect its deposits and carrying on its business is maintained. Thus, the ensure adherence to such fiscal discipline is needed, which means at times even the management of something can be taken over. Nonetheless, as observed here, these are all regulatory measures to keep a check and provide guidance and not a participatory dominance or control over the effects of the company. But the companies in general carrying on the business activities, maybe manufacturing, other industries or any business, but the checks are provided under the provisions of the company side. As we stated earlier, there are also main consideration is that company itself may not seem because of its own mismanagement or interest of the shareholder or maybe the may not be zero paradise from the business. Besides taking care of the business as indicated above, there is no other interest of the state to control the advice and management of the private company. Here is taken in regard to industries covered under the Industries Development Regulation Act, and their production which is important to the economy cannot go down. Yet the business activities carried out by the companies or corporations which only remain the private activities of the such private companies not only not be available to the regulation of activities of the constitution, but in fact, the retail issues of private bodies and persons that there may be statutes which need to be complied with by all the concerned private companies. For example, there are certain legislations like Industrial Act, the Minimum Wages Act, the Factories Act, or Maintaining Proper Environment, Air for Carbon Pollution Act, or Water Carbon Pollution Act, or statutes of like major certain duties and responsibilities statutorily upon the private bodies, which they are bound to comply with. If they violate such statutory provisions, for compliance of those provisions. For instance, if a private employer dispensing service of employees in violation of the industrial discipline, eligible to present the HIGHCOURT and has issued letters of private bodies to companies in that department. The difficulty in issuing a list may arise where there may not be any non-compliance or violation of any statutory provisions of the private body. The liberty may not be issued at all. Other than this, and they may be subject to and para 27. There are a number of the companies carrying the government banking. There is nothing which can be said to be close to the governmental function. The road function is one part of another, carried on the individuals or a group of them. Also, similar in the business are there as well as the profits. Any business or commercial activity may be banking activity, etc., etc. Then, para 30. Clearly, because the Reserve Bank of India lays the banking policy in interest of the banking system, or in the interest of monetary stability, or sound economic growth, having due regard to the interest of the depositors, etc., and provided under Section 5C of Banking Regulation Act, does not mean that the private companies carrying on the business or commercial activity of banking
discharge any public function on public duty. These are all regulatory measures applicable to those carrying on commercial activity in banking that these companies are to act according to these provisions, wherein which certain consequences follow. So, what the Honorable Supreme Court said is, these are not establishments under the statute. Those statute, that is, for example, Cooperative Societies Act is there. The regulatory measures only to properly control the request. Otherwise, may not the depositors and may not borrowers, all of them will be put to loss. For that reason, to have certain control, statutory arrangements have been made. For example, may not report companies are there. Here are government report companies act. Like this, there are the companies are there. They are governed with the companies act. That's because the provisions of acts are there. Only for some regulatory, but not just to be called as an instrument of the state. Then my next citation is from page 65. 2006-11 SEC 634 SS Nana was registrar corporate societies and others. Para 9. That is also a Congress Central Cooperative Bank. That is also. Para 9. Yes. It is not in dispute that the society is not being constituted under the Act. Its functions like any other cooperative society are mainly regulated in terms of the provisions of the Act, except as provided in the bylaws of the society. The state has no say in terms of the society. Membership, acquisition of shares, and all other matters are covered by the bylaws framed under the Act. The terms and conditions of an officer of the cooperative society disputably are covered by rules. Does not contain any provision from thereof, any legal right as there has not been shown before us that the state exercises any direct or indirect control over the office for deep and pervasive control. State furthermore is not the majority of the state has power only to nominate one director. It cannot be said that the state exercises any control over the affairs of the society. It is just that the majority directors are nominated by the state. But having concluded that the state has a deep and pervasive control over the society, several other relevant questions are required. How was the society created? Whether it implies any monopoly characters? Do the functions of society pass state statutory functions or public function? Response number 2. Society does not accept any of the above-mentioned tests. In the case of non-statutory society, control thereof over would mean that the same manifests as created of its own control. It is well settled that general regulations under any act, like the Companies Act or the Corporate Societies Act, do not render the activities of the company and society as subject to control of the state. The controls in terms of the provisions of the Act are meant to include proper functioning of the society, and the state or their statutory authority will have nothing to do with day-to-day functions. That is one of the Supreme Court decisions, which I have read. Clearly, demonstrates that when there is no dominance by the state, either by way of contribution or by way of managing the actions of the bodies, and those those bodies be characterized as the state of instrumented in the function after to by of the constitution. Thus, no it lies. That is then my last friend has drawn my attention to the latest decision reported in 2023 by 548. The Honorable Justice Srinivasa statement. 2023 by 48. The fifth part, the reputation was filed in the year 2004. Reputation number 16193 of 2004. That has been decided in July 23. Should also argue this matter. We have raised the same day, not the land is by the Para 14. In sort of this court relying upon the judgment of the division bench of this court, specifically held in paragraph 6, the reputation has been acquitted in this court for more than 11 years. It is neither just or proper for this court now to refuse exercise of the discretion and dismiss the discretion on the ground of availability needs as follows. So the existence of alternative remedy is not a part of exercise of exemption. Well said is that while the existence of effective alternative remedy would be a factor to negate for imposing the exemption of not the jurisdiction both earlier, but alternative remedies can not been exhausted. So in this case, one of the land judge said that the petition was admitted in 2004. We are now in the year 2023. That is 19 years has been passed by. And your contention that we have to go before some other authorities for getting a justice. This is travesty of justice that is long period of time. We cannot drive into in this case. In this case, of 2018 later case, so fight counter in 2015 case that there is no jurisdiction for the Honorable Court. By seeing the counter immediately, they would have been alerted. They were not doing. Apart from that, another point I want to highlight is this. Here, my lord, question of alternative remedy is nothing. Bar of jurisdiction. Here, my lord, the land judges, with great respect, we are taking steps for writing a written also. Land judgment, not at point, we are taking steps. The land judgment at this stage is taken a view that alternatively of alternative remedy is long, in the long distance of time, we cannot do. Here, the question is not alternative remedy. My content is foreign jurisdiction. Alternative remedy is a different one. When we are having plural remedies, one here, one there. Normally, the Honorable Court is driving the all the persons. If there is any statutory right of image, etc., we exhaust first and then come back to the court. That is normal rule. My contention is this not an alternative remedy. I am saying this court cannot entertain the petition itself. That is entirely different. That angle where a land judge has not answered it. Even though I have cited all the decisions which all those decisions which we have read is not maintainable of the repetition. Whether it is mirrored, argued after a length of about 10 years of the admission, etc. Also, it is has to be sustainable because when this court has no jurisdiction to entertain it, the question of whether granting any relief is not enough. That is our condition. The full bench decision and Honorable Supreme Court decision is binding on the Honorable High Court. So we are bound by the full bench decision that the Supreme Court decision. Sonasimatri cannot the full bench of the Honorable Court decision, or it will is maintained for cooperative banks, cooperative societies. So after this point only, I passed the another judgment for justice for subsequent judgment.
After the Honorable Justice, what is his stand? What is his stand? What is his stand? The Honorable Justice.
No, I want to say is that. And it is with regard to maintainability and same case law that we cited before the land judge. Land judge cannot help us, it's not maintainable. It is the very same land.
Yes, madam.
One submission I want to bring to your attention.
There are,
Judgment.
he read so many paras with regard to maintainability, etc.
What I am going to.
How we are going to satisfy that all the paras? Why? Because each and every para is reaching that your case is not at all maintainable.
In this Milord, we have already we have passed on that because Milord, we have already went for appeal. Alternative remedy is there as per Poland.
He is saying is not the question of alternative remedy. The bar of jurisdiction.
Bar of jurisdiction, what I am saying is, in this writ petition, they are challenging the removal of services. Basing on that, the judgment has been passed. Judgment. They are saying that it is governed by bylaws. We have already governed by bylaws. We have prepared an appeal. Up to bylaws also, they have nowhere it is stated that where we have to approach. That my contention has maybe recorded. After that, pass the orders. First, my contention may be recorded. Not one submission, what I will bring to your lordship is, he is fighting from the year 2004 onward without his mistake. Because there is a between the bank managers and the customer. There is a mistake done by the bank manager, the common person will not, who is the clerk, the entire burden has imposed on that person, who is nowhere concerned in the checks which is altered by the customer. From the 2004 onwards, because of mistake done by the higher officer, the entire burden is on the employee of the clerk will not. Kindly see the same was recorded in the inquiry proceedings also. Because all employees must be dissolved and recovery proceedings has to be initiated against the customer N. Shankaraya. They have already chosen the appeal, he has prepared an appeal. After that appeal, he has given a represent application. They did not say even while taking the application, no, you have to go to alternative remedy is there. I will not consider the application at the threshold, they have to reject it. They have not done so. While making an application before the chief executive officer, chief executive officer could have said that already after appeal, you have to go to labor commissioner. They did not say, said so in their proceedings also. Kindly see that rejection order also. They did not show where the party has to approach. Presume that there is no jurisdiction at all under 226. They could have, while passing an application considered from the petitioner, they could have said in the proceeding says that this application will not be maintainable. You go to civil court or labor court. They're simply passing the order. One side they are saying that it has to be governed by bylaws. Bylaws says that appeal provision has to be before the CEO. That appeal already prepared by the employee of the petitioner before your lordship. No, everything is gone. All remedies have been given by the petitioner before your lordship. Only that application as per the Honorable High Court direction, the application has been considered by the respondent official bank. But what they have to state is that the application cannot be considered because alternative remedy is there. You have to go there. That plea has not been taken in the proceedings also. They are making them the petitioner to running around the court. They are saying that you are because of petitions are pending. That's why we are not releasing your gratuity amount. Kindly see, this will come to a conclusion that mistake has done. Kindly see the inquiry proceedings below.
Punishment rather than not at least aside. We gave by of the petition, indirectly the petition is asking to give the areas of salvation. Okay, areas of salvation to give it departmental inquiry proceedings to give minor punishment under the subject.
So page number 51,
even minutes also are subject to election. Even minutes also are apart from mandatory of the petition. What is the petition clear last week?
Not for the entire record. Without facility, we have to.
What is the reason of TSHC calling for records?
Secretary is cutting. It of mandamus written. In my court copy.
Maybe.
It of mandamus calling for the records of reference. How the
31/7/2018. What is the 31/7/2018 order? It is not a ballot. It is disciplinary procedure, not a disciplinary procedure order.
It is a representation order.
Representation, and it has been rejected, saying that there is no substantial grounds in the representation. They have not challenged the punishment order imposed by the bank.
So,
Yes,
No, one submission.
punishment order they have not.
Let me submit. Sir. Let me submit.
Very clear interpretation, not speculative. Not being able to say, just I will give a synopsis date. All of them are bank employees, are transferred in DDs. And transferring in DDs, my lord, they have given, that's where given benefit to one dealer. The effect of 3 lakh. 3 or 4 employees.
3 lakhs is tampered the entire.
Because they have tampered. Example, my lord, it is 3,000. they put one another 0 to 3,000. That means 30,000. Likewise, Malata, by tampering of the DDs, they Malata misappropriated 3,25,000, 25,500 tax law. That Malata charge promo was issued way back in 14/10/2003. Then Malata inquiry officer appointed, he submitted report in 2004. Then Malata stock out notice was issued. Why you should not be deposited? Because banks want Malata complete funds. But the Supreme Court says not the quantum of the amount. They say the bank employees must exhibit the highest integrity and honesty in charging the business. The article of Supreme Court it can take just from 1,000 rupees per annum. Employee has been dismissed, but has been sustained by the Honorable Supreme Court, saying that 1,000 or 1 lakh and 1 crore is humiliating. Then a local notice was issued, and submitted dismissal from service was passed on 28/7/2004. Was dismissed from service. And for recovery of 3,25,500, but challenging that Ballard earlier the finance petition. And Ballard Honorable Court disposed of that petition, saying that you are having the remedy of appeal before the court final judgment. That petition is not disposed of. And the appellate authority Ballard on humanitarian grounds considered his appeal and passed an order on 31/10/2005. That is the last order by 31/10/2005. Appellate authority's order. He was registered into service, but by imposing a punishment of stoppage of 5 annual grade increment with cumulative effect, and when a dismissal period was treated as due for which he is eligible, and he was directed to remit half of the amount 1,62,000 with interest but interest. That is the order. But penalty provided is not there to be reinstated into service. Removal order has been set aside by the appellate authority. It was directed to be reinstated subject to the condition that he should pay 1,62,500. On the end, he was stoppage of 5 annual grade. This by order, appellate authority's order has been challenged. In petition 2453 of 2006 on various grounds. But the Honorable Court, by admitting this petition, passed a conditional interim order saying that first you deposit 1 lakh, that bank will be reinstated. Then he has deposited 1 lakh and he has been reinstated to service. Then after some departmental proceedings have been over, the cooperative department also, registrar of cooperative societies also initiated surcharge proceedings. And surcharge proceedings are entirely different from departmental proceedings. There are three types of proceedings that are available. One is the disciplinary proceedings, one is surcharge proceedings, one is criminal proceedings. The three have its own consequences and different in nature. Now, my arrangement wants to link with this surcharge proceedings. Now, departmental authorities have also initiated surcharge proceedings against all the bank employees. But surcharge proceedings have been dropped on 23/11/2009. Now, taking advantage of dropping of the surcharge proceeding, the petitioner now wants all the benefits, saying that the surcharge proceedings has been dropped against us. Automatically, the punishment order imposed by the bank will go vanish. How can it be vanished? On that ground, the present petition has been filed saying that I should be given salary for the dismissal period. I should be paid all the amount of 1 lakh rupees which you have received from us. You should pay that 1 lakh rupees. How you are entitled for us? When you are in service, you have received the whatever salaries that you are entitled to, you have paid it. But if they this petition which they have filed challenging the appellate authority's order, that is petition 2453 of 2005. When the petition came up for final hearing, here they have committed, they themselves must be blamed. They have committed a grave mistake. They have argued the matter on merits, but they are challenging the appellate authority's order. They have not challenged, they have not argued the matter before the land. On the other hand, they have made a representation to the Honorable Court saying that subsequent another department proceeding was initiated against him. Again, another punishment order for recovery of 1,000. Now, in the petition, what they have stated, because of surcharge proceedings have been dropped.
all these things are subsequent events. So I will be permitted to make a representation to the bank. This honorable court will dispose of because they themselves has asked this honorable court to dispose of, saying that I will make a representation to the bank. Bank will make considered of the court. That means the appellate authority and order passed by imposing punishment became final. Even in this liquidation, they have not challenged the appellate authority. So what they are now challenging is the rejection of their representation. So rejection of their representation is what they have given reasons also why you are not entitled for all the claims claims made by you. Which my lord, the bank has rejected it. That is at page 14 of the material. What is the illegality in this order? There is no illegality in this. Rejecting the representation, page 14 not materials. Mallaya, retired manager, submitted a representation which was received by the bank. Where we have sought the relief of 500 credit payment. How can it be released? This punishment order became final. Treating the period from so to so as on duty and payment of salary. How it will be treated as a duty? When you have been reinstated to service, clearly there was an order saying that the new period, the period, suspension period will be lost and they were loss of duty. Treating the suspension period as a duty from payment of salary. Refund of 2,53,000 kept out of country account. Refund of 1 lakh rupees deposit. Payment of interest and gratuity for a delayed payment. The above representation was made by the purchase of the order dated so. The said representation has been made to both and both after thoroughly verifying the records, keeping the previous proceedings issued by the bank, rejected the representation of the third employee and without any substance for the reasons. Mallaya was inflicted with punishment of stoppage of 500 credit which could be a bank. Treating the period of dismissal as leave to the extent of eligibility and remaining period as leave on loss of pay. Remittance of half of the amount of so and so. This rate will be paid after remittance of the amount. This punishment was imposed by the committee on 4/10/2005 and considering the appeal challenging the dismissal order. That proceedings became final and stands for good. Even the Mallaya by petition, currently said producing, he has not obtained any order from the Honorable High Court. That is the idea of order. The Honorable High Court disposed of the petition, permitting the petitioner to submit the proposal. The contention that joint registrar property surcharge proceedings industry, involved with the topic of surcharge proceedings, fixing the liability by the so and so by the mathematically more, and is not liable to be anymore. But the contention did not apply that in the case of finalization of the discipline of proceedings for the court. Surcharge proceedings are different and discipline. The result is not proceedings has no bearing on the and the contention of the retired employee is unsustainable. So my lord, when punishment order became final, it has not been set aside by the Honorable Court. So where is the question of now seeking the
All these benefits.
how is entitled? So on the merits of the case also, my lord, this is only my privilege.
Why you are not challenging
Petition, my lord.
Why you are not challenging the order? Dismissal order.
Dismissal order kindly say me what. And the bylaws which now I have passed before the also. They are saying that why they have not preferred appeal, why they have not, since the beginning, they are saying that appeal has not been preferred. Kindly see me no. Page number, just now I have given pass on. AP Cooperative Central Bank employees 18,600. Just now I have given. Judgment not available, that's why. Prior to that, before I start the argument, I pass on the 18/6/2012. Flag also is there. I kept the flag. Did not kept the flag. The other which I have passed on, every flag also.
ಇಲ್ಲ
ಅದೇ.
ಇಲ್ಲ
Otherwise, I will pass on this. But in that, the appeal preferred before whom it has been clearly stated. Even the recovery of money also, chief executive officer is a competent authority. So my representation has been treated as appeal only.
Correct, but why you are not saying that order?
That is what I am before your lordship is.
This is one way or the other, you made a representation.
At the direction of the Honorable High Court.
Accepted or granted.
Yes, Minister.
That you are agreed by them with rejection, but main thing is that you are not challenged the dismissal order.
That is what I, in that writ petition, we have challenged in dismissal order. We have writ petition. Instead of the council who has represented before the Honorable High Court, they have stated that new facts has come.
Correct, but not set aside.
Not set aside, but the new facts has come on the basis of the request made by the council. He has filed a representation.
You are a senior counsel, madam. Think over it.
Yes, Minister.
Once dismissal order is pending, not set aside by the any of this honorable.
I agree with your.
Ask any benefits under the same order.
Benefits only, I will come.
Ask that.
I will come to that conclusion and kindly take up this matter tomorrow, I will finally.
Day after.
Because just now they have given a judgment.
The problem is, your argument is over, na?
Your colleague is.
When do you want? When do you want? They have to.
Stating against them. That are in the standard. Not imposing punishment. It was not
The order is not satisfied. Without that, without satisfying of the punishment order, how can you ask any benefits, any scheme, any?
Yes, sir. I will come, I will satisfy this court by day after tomorrow.
the post of the 2 weeks. Madam. What madam? Madam. What it means? What do you want to say finally?
Teaching is not a challenge, only 5 is at a time.
No, finally under challenge. So can we proceed with the matter?
Yes.
Answer stayed, huh?
This is 2023 transfers has been changed. Not at all concerned with 2023.
No, this now the election is there, sir.
Election is suggested. Lordship school title is always like that. They do it within the election period or not, automatically not any of that. Even if the judgment comes in my favor, that they will implement after the election results are declared.
First, you have to satisfy this court.
Yes.
What indiscrimination taken place in your
Yes,
case?
exactly. But
The counter is not there. What to do, sir? You have a written instruction now, you think? Not good. We are calling every time senior counsel like this. Last occasion answer every time it's coming, man. You have to warn. That's the other gentleman we have to find this. Well, Malaki is it? So it's not coming copy to copy. Yeah. You have copy with you, sir, any written inspection?
usually have such privileges.
Last time what I asked you to use, sir, produce the.
But last time what you lordship asked me is that when offers are called for, that my specific grievance before you are. Not as per the rule 5. The rule says that if a NCC candidate, that a school provided for an NCC unit is there. In a school not NCC unit is there, NCC candidate should be posted. In my case, not my grievance before you not contrary to the rules, that they have posted that the persons who are not having NCC, that 1 to 10, have been posted in the 11th school. So therefore, 1 to 10, that is all the 37 page 37 is not.
No.
Maybe
I asked you, sir, produce particulars of the schools, whether they have the NCC.
Yes, exactly.
Your right, your statement is right or wrong.
Yes, exactly. I have this, that I have produced it. That is all you not.
37, yes.
In this, your lordship last time asked me to produce up to, my grievance is not up to 10. That these persons are not having blood NCC.
Okay.
Though some persons are not having NCC in these units, schools, but still they have been posted. I said, then what is the evidence you have to show that? Because these options are called for only from NCC candidates, because 20 schools are NCC. So if these are all NCC schools, therefore I also extend that option. But my grievance now before your lordship is a candidate who did not possess the NCC certificate has been posted up to 1 to 10.
Show me that evidence.
That's why. That your lordship can see the morning I have passed done.
This nothing is understanding, sir. What is that? I am not.
No, that I will explain, but I will explain.
You have copy with you, madam? Yes.
58 serial number you launch for English. First I will read that. Reference 1. Blood compulsory. Uppal school. Blood TSHC Nagor. Uppal Mandal. TSHC Nagor. 2. That means not 2 NCC schools are there in Nagor. 2 NCC schools are there.
It's not NCC school, 2 plain.
No. The entire options are in respect of
Reference 1 compulsory, Uppal, so and so, ZPHS Nagor, -2 plain.
No, plain is not logic for IDC. ZPHS school plain and blood tribal blood vacancies are there. So therefore, blood these are all plain schools only. Nagor is a plain area, blood is not tribal area. Tribal area. So therefore, blood is a plain school. Blood. There is no dispute in it. Only thing is ZPHS Nagor, there are 2 schools, 2 posts, NCC. Blood, one is filled by 58, another is filled by 61. You not kindly say at least that. $58 and 61. 58 you not kindly see that. The tabular column. This is the list published by the regional joint director. Rangareddy. That you not kindly see that column number.
Rachala Madhavilata, teacher name,
10.
teacher type compulsory.
Yes.
And current school ID so.
Yes.
Current school
Then current
Ganded. Not
also
Ganded, not
yes. Ganded. Then not category of the post. School assistant English. Then not current school. MGMT. NPP Jilla Parishad schools.
Management current area plain.
Then current area plain. Then last this column is very important. Blood current NCC officer status no.
No.
This gentleman blood Rachel Madhavi Lata. Name is not the third column you are not kindly see. Teacher's name.
Oh, yes.
Teacher's name is Rachana Madhavi Lata. So she is not having NCC. Current NCC officer status no. Then not your lordship kindly see. Last column blood ZPHS Nagor 1.
Allocation school name ZPHS Nagor.
Yes.
After. Yes.
That she is female. That she is not having NCC certificate. Then blood she has been posted to ZPHS Nagor. For which I have exercised very first option for the ZPHS Nagor. These are all my options which I find before your lordship in page 37. That's why I asked your lordship blood to compare both these things. Blood your lordship has to see both statements. My first option is ZPHS Nagor. So I am an NCC officer. I am in blood NCC certificate, NCC school. So I have been asked to exercise my option only for NCC schools. I have exercised 20 schools of NCC blood having in Rangareddy district. NCC unit having in Rangareddy district.
But according to the statement, this is not NCC zone school.
So it is an NCC blood.
No, in the current NCC officer status.
Current NCC officer, she is not having NCC.
Not having that school have not NCC.
No, NCC. She is not having. She is not having.
What, madam?
Current NCC officer status is she is not having. She is not having. Last year, lordship kindly similar serial number 21.88.
Now we'll see 11th option. Where is the 11th option? Which school is opted by you? 11th option, 11th,
Anil Kumar.
11th one,
11, your lordship is asking blood Anil Kumar.
Anil Kumar.
It is also blood, he is also not
Your
yours.
school is which place? Mitchell, 11th seat was allotted to you, 11th class school.
Yes, blood.
That is ZPHS.
Page 22, blood serial number 22, your lordship, you see J. Prashanti. J. Prashanti.
She is your client.
Yes, blood. He is the petitioner, blood before your lordship.
J. Prashanti.
J. Prashanti.
Okay.
Serial number 22.
Compulsory.
Blood compulsory.
Uppal.
TSHC Uppal. Earlier school. Current school name, your lordship, you see top.
Sir, what I said is right, sir. Current NCC officer status means that school doesn't have NCC. See, this is S. 22, Shanti, compulsory.
Yes.
ZPH Suppal, MPP, ZPP school, plain. And current NCC officer status is yes.
Yes, she is having NCC certificate.
But how can you? Your contention is that she transferred without
No, my contention is your lordship, please. Last occasion, blood, your lordship, in the school also. My contention is very simple.
understood, sir. But where is wrong in
No,
it?
no, that's what I am submitting, that your lordship, kindly see page 37 top plan. Unless your lordship sees those columns, your lordship will not get that. Your lordship, kindly see that the first column medium interest to avail this house benefit. Medium Telugu, then blood J. Prashanti, blood your lordship, kindly see present working place, blood preference, then blood school name, ZPHS Uppal, blood her medium is school assistant, transfer type, blood compulsory, because I have already completed 8 years. Area, blood the plain area. Then third column, your lordship, interested to avail this spouse benefit. No, there is no spouse category, therefore no. Then blood preferential category is there, present working. What is the preference I have? Only thing is working as NCC officer. That is the preference I have. Then blood Uppal, I said yes. Worked in ZPHS. Government high school blood. THS. So then blood, my preference blood, I have exercised all these 20 preferences. Options. We will call it as option because in the rules it says option. So I exercised blood 20 options. My grievance before your lordship is blood up to blood 21 blood, up to 22nd, up to 21 your lordship IDC. No officer, blood, no teacher blood having NCC. They have been posted to all the schools blood which are notified as NCC schools.
According to you, 1 to 10 are NCC schools.
1 to 10 are NCC schools.
But here the statement
Posted
status of NCC means there is no, if it is NCC,
yes.
there is no all or no means that particular person has to have NCC.
That person doesn't have the NCC because Prajari is having NCC, that's why they said yes. Likewise, there are other cases.
Understood? You have to understand first of all, court and you.
No, your lordship understood. She has to understand.
No, wait. They have to how the mistake was taken place. How you transferred this person to 10th place, 11th place. There are NCC schools are there, and you have given priority, last priority to her.
I'm going to clap.
Yes.
Let's They have to be. The lordship is having.
This is the 24/10/2018, madam. Proceedings of the Director of School Education, Telangana, Hyderabad. What you said in this?
Third point.
Further, the individual in her appeal has stated that only NCC schools vacancies are shown in the web counseling and not shown the general school vacancies. NCC teachers shall be posted in NCC schools only. Compulsory vacancies of NCC schools were not displayed for her during the web counseling. Some NCC teachers were retained in same school, even they are under compulsory transfer. Some vacancies of NCC schools were not filled up in the web counseling. Accordingly, web counseling was conducted by the department and Shivati G. Prashanti and exercised 20 web options seeking transfer, and as per her options, she was posted at TSHC Girls Mitchell, that is NCC unit.
That day will tell that. Anyhow, I am also not disputing that. I have given 20 options, sir.
Further,
But luckily, I may got 11th option. But suppose that there are all 19 officers are NCC holders, all my seniors, automatically I will go to 20 blood. In such circumstances, there is no wondering it. I have been posted in after based, that is altogether different. That is not at all my grievance. I never came to this order before, that is my grievance. My grievance is 1 to 10 are not having NCC. Why you posted in
first to 10th were filled with seniors as per the rank.
No, seniors you not. Seniority will not come here. Because
that is the opted first to 10th were filled with seniors as per the rank and their entitlement points, and she was transferred to her 11th option, which is exercised by her own choice.
no 11th, you not 1 to 10 they say that,
Seniors than to specialty.
but they are not having NCC. That school is NCC school, you not
Yes, sir.
School is NCC school. But these people are having NCC senior, but I have no grievance at all. State lordship can dismiss my case.
Yes.
Absolutely. My grievance is these persons are not having NCC certificate. How you posted them as a
And that will also I think.
But the government of India instructions are not page 36 we find blood your lordship IDC. Ministry of Blood
No, in this angle also I asked if they are how they are seniors. There is some options that seniority will come priority wise.
these are all online options.
Their instructions are there. You read already, so many things. How the seniority will come. If they are Shanti is the junior than the about 10 members, nothing to do with that.
No.
As per your contention,
Even assuming blood, I will admit that they are seniors to me according to their instructions. Even then, blood, they are not having blood NCC certificate. So they have to be posted.
according to NCC people have to give priority.
The government of India instructions, Ministry of Defense says, give preference to the NCC, post them in NCC schools, don't keep them vacant. But the lordship knows education is funded by not 60% from government of
Madam,
India,
what is there?
only 40% state governments.
Having కాదు priority gives to NCC. The point 10, the first school ZPHS.
Now there is one post in Ramanpur. There is one
Whenever you convince that your department people, there is a vacancy in Ravandapur, transfer her to Ravandapur, where the NCC is there. Anyone? Tomorrow and day after tomorrow?
day after, sorry.
Next week?
Not your lordship, but I will see para 9. I have not stated that I submit that I am an unmarried woman and it is very difficult for me to travel not more than 150 kilometers to every day and not 2 and 4. But then Lord, I submit that as per the rules are amended to better placement. In fact, the government, state government introduced web counseling have to be transparency in affecting the transfers. In the instant case, the third respondent violated the statute rules. Therefore, it would amount to exercising the arbitrary power in violation of Article 14 of the Constitution of India. If this honorable court would not intervene,
Okay, next week we'll see that then. Madam.
on Ramantapuri, if your lordship can direct them to consider in Ramantapuri existing vacancy. Whole issue will be resolved, not your lordship at 1 minute. Your lordship is having not 1 minute. And it is experience what I say is that your lordship is having jurisdiction, examine the law. Lordship is having jurisdiction. If there is any violation, your lordship can.
Now
we say. This is our present scenario. The lordship is having jurisdiction of equity also. Coupled with the equity coupled with, then only blood we can say that it is justice. Otherwise, blood your lordship can kindly see when there is vacancy available as that today. Apart from all this, not that I am not having merits. Not that I am not having merits. Not in my case.
As per the petition's information, Ramantapur vacancy is there. Directing the respondents, whether it is vacant or not. If it is vacant, transfer has to be Ramantapur case.
So I find information that I find copy. Let my learned friend that in the September 2023 I find a copy. Is the RTI information supplied by them.
When do you want? Next week. Okay, next week.
There are 2 judgments of this honorable court that where a rule is violated, you must be having power.
Next week.
So when Monday is holiday, Tuesday will not. 14th.
You have to get Pakka instructions, madam. Next time, if you don't want to engage senior counsel for this case, more time. Finalize this after.
Also, make a way to 57. Pension was low.
Pension only we are paying.
Pension?
Only pension. The lordship, as per Supreme Court judgment, apex for this. Any pension which is due from the government venture, government department, government rate, has to be paid with 12% interest per annum. Your lordship, I even passed on the judgment of Bihar High Court, Patna High Court judgment, in the last occasion of your lordship. And another voucher. Patna High Court, wherein it clearly emphasizes the need for the government institution to pay at least 12%. My lord. Lordship, you kindly say at the backside of the judgment, 15th para. Your lordship, you kindly permit.
Where are you telling only pension you are taking?
Yes, my lord. And whereas I am seeking in the judgment also given by this honorable High Court. Yes, stated that very power or pension. Whether has given the copy of the lordship kindly concise the authority training instructor having paid pension. Your lordship, kindly.
No, one second. You have to say the implement rejection order, so and so passed by the respondent number 2 is accepted and consequently respondent directed to complete the service of the petition from date of appointment that is free for the purpose of sanction of pension within a period of 2 weeks. Yes. And the interest portion, how much granted?
Interest is not being granted.
Yes, ma'am.
My lord, it is the guidelines of the Supreme Court which reiterated every now and then. Lordship, I kindly consider that
What is the regard interest, madam? Supreme Court directions is there.
When in the Patna High Court, even
High Court 12% they are asking.
Your Lordship, you will be surprised to know that AP High Court also gave the similar guidelines with regard to the pension should be paid with 12%. Lordship, I kindly see backside of the para 21, para number 21. Therefore, while disputing writ appeal number 26 of 2023 and 1000 of 2022, writ appeal number 952 of 2023 is allowed in part only interest of 12% per annum instead of 9%. Already, this on High Court, Andhra High Court gave the judgment for 9% and it modified it to 12%. Charges will come. That situation, they have given the interest rate. They got for this. Pension year. This is a wrong statement, so they have given the interest rate. Your Lordship, you have the APJ.
All the
Regard to this additional concern, they have to give pension as vocational instructors.
all 17 numbers.
Yes, as they were regularized, pension. From the date of regularization, we are getting pension, my lord. But whereas from the date of initial appointment, we are seeking pension, my lord, along with pensionary shield. Even but we are not still getting any pension. That is the plea. We are getting from the date of regularization, not from the date of initial appointment, as per contract to the national investment. As per this order, they are getting from the date of initial appointment. As
From the date of appointment, 30th till 1990, for purpose sanction of within a period of 2 weeks. Where is the, in this case, when they are appointed?
they were appointed at different timelines ranging from 1985 year, 1985, 1986, 1999. So
Regularized?
regularized in the year by virtue of GO number 31. Dated 2009, your lordship, they were regularized. 13 to 2009, by virtue of GOMS number 31, they were regularized in the year 2009. Here, this is appointed in 2000. They have been appointed. Lordship, apparently, of the what promotion?
We submitted a procedure qualified under
The different as per para 3 of the affidavit,
they are selected and appointed as vocational instructors in different disciplines. And found actually like knitting and garment marking 1984 to 85, 88 to 89.
there are different dates change. They were regularized, but as per award order, they are getting from the date of initial appointment.
The government has issued during 31 years to regularize, so 2009.
Yes,
So now they are asking the pension 1984 to 85 ఒక batch 1998 to 19 another batch.
yes. My lord, as per the Supreme Court judgment, we are seeking her. This really reasonable.
Challenge may order.
Yes. No, my lord. We already age-old persons, my lord. One of the petitioner is suffering from kidney failure, my lord. One is
One second.
if one is paid, then again these several petitioners.
No, once you have to follow, the courts are different, madam. Our high court to pass this order, correct?
Yes.
Without any interest. This will consider the same.
Your lordship, if
They
kindly
challenge, you can,
as per, if I did
you
not.
challenge it, madam. Why? Because you can't
My
pass
lord,
other
I-
courts.
Because of the age factor, your lordship, I kindly consider. Literally, they are on footsteps, my lord. You see their prayer, your lordship, their prayer is to initiate and implement the orders of OA. OA number 8904.
What is that OA order? Declare implement action, respond not implementing the orders of the government. Where is the OA order here?
OA order is at page 30 to 51, sir. 51, my lord. Even the judgment that tribunal has relied upon clearly emphasized for pension and pensionary benefits, my lord. At page 48, my lord, of the regulation.
So this is the OA.
Yes, ma'am.
Implementing the OA is the question.
Lordship, even on the OA.
No, this OA, you are not implementing the OA order, no? No, the OA itself, your conditions are declared 13 to 2009. That's what. Yes.
The Lordship,
No, no. So challenge my order, madam. Test my order, that's all.
My lord, one submission, my lord, one final submission. My lord, one final submission. My senior will appear on this matter day of it. Lordship, kindly consider.
Post after 2 weeks.
My lord, tomorrow, my lord, day after
Post
tomorrow.
after 2 weeks, sorry.
My lord, one of the petitions.
Post after 2 weeks, sorry. Yes, next. Consideration of petition. Become 64. Three Rachana. Three Harsha. Three Rachana. No, if you are, madam, you want senior one, sorry, don't waste your valuable energy for all this type of cases.
My lord.
Take adjournment and ask your senior to come. You are arguing well, and at the time of final, you are stopping that. But
My lord, 12% interest is
Not
very
10 days.
as per the apex judgment, my lord.
I dismiss your senior will come.
My lord, I will argue.
Yes. Be Rachana.
Yes.
Pleasure.
This matter relates to Mallard's wherein petitioner believes that he was medically unfit
Where is senior in Gardens?
He is coming for the 4th or 5th, but there is my only relief is that what I'm seeking is
You know that without hearing the other side, I want to.
even that will not affect the velocity. The only thing I'm seeking is that IA1, which is to re-examine the petitioner, because according to the rules, Mallards, he has. According to the rules, he has to be sent to the competent medical.
No, without hearing other side, whether re-examination is mandatory or not, whether re-examination is possible or not.
Medical board, Mallards, if the report is in my favor, then it's finished. You know, if it is their favor, then it will become, can be dismissed.
I will challenge that order again, it's petition. It's a process.
Because it's been 4th or 5th, I mean, nothing will affect their velocity. Even if petition is sent to medical board, that itself will define whether my petition is maintainable or not. The lordship is the current movement page number 22.
Okay, we'll put it for orders next week.
This week, because it's been 4th or 5th time, neither counter is filed, 2018 petition, neither counter class they are appearing. The lordship also is not, there is no representation on behalf of respondents.
There is no representation on behalf of respondents for the last several occasions.
Yes.
Finally, post the matter for orders next week. And if the respondent council is not available on that day, the IA1 of 2018 will be allowed.
65. A round for services one. Is signed by the respondent. Not related anything of our service, but for the friends.
Same case, last case,
In fact,
you find OA.
do not go directly.
You are fitted to earlier case. No, not in fact, tell me in fact.
So my services are regularized. Government directed
When your services are regularized,
2000.
when your initial appointment,
That is of 1989.
89.
89. I'm asking for regulation to 93 onwards. In fact, government take a decision to regulate my services in the 1995.
Okay, this is also next week.
Yes.
95 government take a decision. Authority competent to regularize taken 5 long years for regulating my services. Ultimately, my
So this
services
is
are
asking from 95 onwards. What do you say? And get instruction whether, no, madam, you get instruction whether 95 their services were regularized.
It is there on the card.
From 95 they want the pensionary benefits.
And if they are asking that, of course, at least 95 credit is granted where that could be sufficient for me. But government has taken a decision, issue a GO in 1995,
directing the Commission of Litigation to government, when the pension started 98, from 98 onwards, huh? 95. 95. Government is a GO, directing the regulation of services in 1995. Ultimately, that process was initiated, Commissioner finalized it in 2000. Because of that, I lost 5 years of service. Actually, one I'm requesting to count that service period and for the pension, and not any monthly benefit. The law is very simple, madam. He is asking 95 onwards.
Yes.
Yes. And counter is already filed. Decision bench already taken decision. What is the decision bench? Decision bench, relying on decision bench, everything is in court. Already concluded, still decided. This is not division bench. But relying on division bench, last kind issue. Same. Totally. Not that. Where are 2 minutes? This is there from the data of initial appointment. They are asked. Appointment. They are asked to be appointment. But the appointment. Okay. Same post matter was posted next week. We'll close down the day. Okay. Yes, sir. It would get instructions. But this case is different from 95 is asking.
Yes.
When you are regularized? 2000. 2000 regularized is asking back 5 years service. So from 95 onwards, he wants regularization. Pension benefit, not regularization. Only for purpose of pension only. Asking for any modern benefit. Okay, sir. For the period. Item 66. State thermal road. Reassurance. 14. Yes, Singer also Mali again absent.
Because here there is small issue. In fact, they have implemented by Viva, but when you ask me, that's the only issue. Here, what has happened? Just by a few minutes, we have understood.
No, without hearing other side, how can waste of time? Nothing but waste of time. Okay. In this case also, the respondent counsel has absent last several occasions. Finally, post the matter for orders next week. No, okay. Item 67, 68, item 69. Arun G. Reddy. Arun G. Reddy. Arun G. Reddy. None appears post after 2 weeks. Item 70, C.H. Ganesh. Yes, Vijay Prashant. C.H. Ganesh. Petitioner counsel absent post after 2 weeks. Item 41, Ajay Miller. Why? 4 weeks. 19 matters. 2 weeks, sir, 3 weeks. Which way? Which item? 70 post after 3 weeks. Item 70, 71 Arjun Miller. Item 72, P.V. Krishna. JP for services.
They model is there, they have passed the speaking orders.
Okay, next week.
Next week, they will send some.
Item 73 Arjun. Oh.
Yes. That's all.